Lordship, I'm sorry, it is the past matter. Your Lordship, in this matter, Your Lordship, on the last occasion, directed to file an affidavit, Your Lordship. Your Lordship, I have called for the record, Your Lordship, it is Berhampur. So, Your Lordship, this week, over sought adjournment may be granted.
All right. At the request of Mr. Mishra, who needs some more time to ascertain the factual position and file an affidavit. List on. March 21st.
Grateful,
The
Your
affidavit positively be filed at least 1 week prior to that date.
Grateful, Your Lordship. Up together.
Oh.
Supplementary list, fresh admission item number 2.
This matter, PIL challenged the levy of GST, the constitutional challenge on the levy of GST on the grounds that it militates against the basic principles and basic feature of the constitution of federalism, as well as it has resulted in extreme hardship and agony for taxpayers and consultants, my lords.
No, these
That
prayers are
Kama
this is very
Millards?
broad, sir. This is challenging the whole act. Can't have a challenge to the entire act, sir, please. You'll have to modify your prayers. Withdraw and file a proper petition. And so much has happened in 7 years.
Yes, that is right. my lords.
There's no question of entertaining a petition like this after 6 years, 7 years after the...
May I modify the petition?
No, you file a fresh petition, sir. You say, in considering that the
Millards,
goods and services tax regime has been operational for well over 6 years now, and there have been so many developments in terms of meetings of the GST Council and amendments to the Act and circulars and resolutions and notifications come up. The petition would require extensive restructuring, and the prayers would have to be precisely tailored, specific to the provisions which the precise provisions which the which are sought to be challenged. Consequently, permitting the petitioner to withdraw the present petition with liberty to file a fresh petition, accounting for the other developments. The petition is disposed of.
Well, I just wanted to bring to your lordship's notice, so far as the challenge on the grounds of federalism is concerned, that has been made by the Honorable Supreme Court in Union of India versus Mohit Minerals Private Limited in 2022.
Then that already answers it. Then no need to repeat it.
No, but the other grounds where you are facing hardships and relating to
You
the
have to be
working.
very precise, sir, because so many things are happening.
Yes.
It won't be possible for us to handle like this one. Just it's like
I can understand that. But similarly, Delhi High Court in the matter of income tax, the difficulties they are facing at the time of computation in Union of India versus All India Federation of Tax Practitioners, lordship had gone into and had
that was
passed.
very precise, sir. That was very precise. It was very narrow. It was on specific issues. Not like this. Imagine somebody files tomorrow saying Constitutionality of Income Tax Act. You think any High Court will be able to deal with it? Cannot.
No. We were on a particular ground that it militates against the principles and features of
the whole act.
federalism.
You want the entire act to be struck down then. That's your prayer. Your prayer is the whole GST Act should be struck down. I know. Yeah. All right.
Our president may be rotated.
All right.
Item number 3.
Well, item number 3, no instruction.
No instruction.
In view of the new policy, this is
Anyway, he says no instructions.
Item number 4.
My lord, item 4, I request for a short passover, my lord.
All right.
Item number 5.
Well, item number 5, a small amendment is required. It will come next week. Only prayer portion inadvertently I have some omitted. And in paragraph 4, though I have narrated that the opposite party, private opposite party has come before this lordship court, in different rate application, I have to mention the rate applications numbers. Only these two things. I pray next.
No, you have another problem, sir. This representation. Where is the proof of submission of the representation?
My lord, only we have to submit before the authority. No communication is there.
No. There has to be a diary number, stamp, nothing. No date stamp, nothing.
No, my lord, we have submitted, they just kept it.
No.
No, then
That doesn't happen like that.
then-
Sir.
yes, my lord, that is happening. Yes, my lord, I fairly said, my lord, in village.
But we are not able to entertain like that.
Then, my
There
lord,
are so many others who
May-
show us proof of.
may I pray, my lord, one thing?
You withdraw and file a better petition, sir.
No, but I will ascertain the date, on which date they have appointed.
Not like that. Sir. You say, then you have to plead that, you have to show some proof.
Yes, sir, I will prove, I will submit some proof, my lord.
What
will-
proof will you submit?
I will ask them how they have submitted and what is the proof there.
No.
Next week, let it come.
You file a fresh petition. Counsel the petitioner seeks leave to withdraw this petition, liberty to file, make a fresh representation. And after receiving proper acknowledgement of the submission of such representation and following up on such representation, to seek appropriate remedies in accordance with law. This post office withdrawn with liberty is paid for. Right.
My lord, liberty, right?
Yes.
Yes. Item number 6.
May it please your lordships.
Yes.
Lordship may kindly see Annexure 1, the Panchanama. In the Panchanama, my lords, 32. Lordship,
Why not law be over, sir? There's no stay order, nothing. This is a 2016 petition.
2016, my lords, assessment is also not done.
It's for 6 years.
6 years.
How can it?
And it is, yes, my lords, and let him take instruction, my lords. Within 21 months, 153B. I didn't obtain any stay for last 6 years, and they have to complete it within 21 months.
Then
from
why
the
worry
date
at
of
all?
the-
Whenever they do something, then you come to the court, sir. Why should we unnecessarily entertain? If nothing is happening, why should we entertain at all?
No, the question is, my lords, whether the loose seats can form.
So whenever an assessment is complete,
Very
when
good,
you
ma'am.
challenge that, you raise all this. You say Mr. Rai states that to the best of the knowledge of the petitioner,
Yes,
for the last 6 years, despite there being no stay granted by this court,
no
the
assessment.
assessment
has been-
proceedings are yet
Yes.
to be completed.
Yes,
Full stop. Paragraph. If that be the position, then if and when an assessment order is passed,
no, my lords. May I interrupt for a minute, my lords? If your lordship's kind permission, my lords, I can raise the question of limitation. Liberty may be given
yes.
to raise the question of limitation
Yeah.
before the assessing officer.
Yeah.
That your lordship may kindly observe.
All right. It will be in that even in the circumstances, if the assessment proceedings continue, it will be open to the petitioner to raise the plea of limitation before the assessing officer in accordance with law. And if an assessment order is passed, to seek appropriate remedies thereafter, raising all the issues urged in the present petition and other issues that the petitioner may have in accordance with the petition is disposed.
Much obliged, man.
Right.
Urgent statement.
Yes, of course.
Item
Yes.
number 7.
May I please?
Yes.
But here the petitioner challenges before a lordship, the order passed by the Joint Commission of Central Tax, wherein the purported so-called notice was questioned by the petitioner. If your lordship turn to page 19, annexure 1,
Appealable order, sir.
my lord,
Appealable order.
it's appealable. Well, question of mentality I challenge. That was not discussed. Your lordship may allow me to file appeal,
That's-
and with a my lord, may only pray my limitation be considered by the.
Yes. Counsel the petitioner seeks leave to withdraw the present petition with liberty to file an appeal as provided in the statute in question. If such appeal is filed not later than 1st March 2023, accompanied by an application for condition of delay, citing the present pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any matter.
I am appearing for the
This
department.
post was withdrawn with liberty spread for the above terms. Mr. Mistress.
Item number 8.
8, my lord, may be permitted with the liberty to file fresh application.
All right.
Cause of action survives.
All right. Counsel the petitioner seeks leave to withdraw the present petition, liberty to file a fresh petition, if any cause of action survives. Dismissed.
In this case, I am appearing for opposite party number 3.
With liberty spread.
Item number 9.
May I please, lordship, here the petitioner challenged the attachment notice. Now the attachment was lifted. So, instruction, my lord, please.
Due to subsequent developments, counsel the petitioner states the petition has been rendered infructuous, it is disposed of as such.
Item number 10.
May I please your lordship? Lordship may kindly see the impugned order
at page 12, 65 crore penalty has been levied by the cell tax officer, who the cell tax officer has not been delegated by such power. The joint commissioner, deputy commissioner, and the assistant commissioner has been delegated with such power. The cell tax
Again,
officer.
you can file an appeal, sir.
My-
Should be interpreted.
My
You can file an appeal.
revision is there, my lord. Second,
revision,
Annexure
whatever.
2 is revision.
Counsel the petitioner seeks leave to withdraw the
My,
petition.
my lord, I have availed the statutory remedy. Second, Annexure 2 is the revisional order conferring the penalty.
All right, you say notice. Mr. Mishra accepts notice. Reply be filed within 8 weeks. Adjourned up for the next week. List on 16th May.
Mine.
Item number 11.
In this case, the petitioner challenged the conditional stay order passed by the commissioner during pendency of the second appeal before the tribunal, directing the petitioner to pay the entire disputed tax amount. Whereas the statute says, when the assessee prefers on second appeal, if he pays 20% of the tax amount, the balance amount will remain stayed during pendency of the appeal. The petitioner has only paid 10% and preferred this stay application for complete stay realization of the disputed demand. The commissioner
What do you
directed.
say? Why should we pay the entire tax?
Your Lordship, this is the assessment under section 42A, Your
Yes.
Lordship.
Mhm.
42A, Your Lordship.
The statute.
He has to file for section 78. Your Lordship may kindly look into section 78. He has to file an application before the authority. That automatic stay is not applicable to this case, Your Lordship.
No, there's no question for automatic stay. He
Your Lordship,
says,
so far as the 20%, after 20% payment, the balance amount is to be stayed. Your Lordship, that part is not applicable to this case. Because in this case, he has to file an application before the commissioner. And
Yes.
commissioner will pass the order. And here the commissioner has passed the order to pay the 100% tax and stay the balance amount of penalty, Your Lordship. Your Lordship may kindly look into the order of commissioner.
the penalty is some 64,000.
Your Lordship, that
Tax is
penalty has been
20,000.
That penalty has been stayed, Your Lordship. Your Lordship, may kindly
And
look
has been
into
amended, my lord.
page 22.
The statute says 77.
Your Lordship, I'll take instruction on this issue.
If the assessee pays 20%, then the balance.
Second appeal.
Yes, I filed second appeal.
You are in second appeal.
Yes, I am in second appeal.
So 78 is something different.
77, my lord.
77 is first appeal.
Yes,
78.
yes,
You are in 78 now.
yes. 78 has been amended, my lord.
Yes.
Amended.
78
Yes, I have
also.
given that.
30%. It's already amended, sir, 78.
Your Lordship, let me take instruction.
What instruction?
I will pay another 10%, balance amount will remain stayed. I have already paid 10%.
Total 20% of the tax and interest.
Yes,
78 says that. You
Yes.
say the challenge in the present petition is to an order dated 17 June 2022 of the Commissioner of Sales Tax Odisha. 28 June, sir. 28 June 2022, the Commissioner of Odisha. In a revision petition filed by the petitioner assessee seeking directing that the petitioner should pay 100% of the disputed demand, subject to which the balance penalty amount would remain stayed during the pendency of the second appeal filed by the petitioner assessee. Paragraph. This court has heard the submissions of Mr. Sahu, learned counsel for the petitioner, and Mr. Sunil Mishra, learned standing counsel for the department. Paragraph. Section 78(6) of the Odisha Value Added Tax 2004 stands amended by way of notification dated 21st June 2017. And the amended section 6 now reads as under. Reproduce this A to A. Paragraph. Consequently, as far as the impute order is concerned, it requires to be modified by directing that subject to the petitioner depositing in all 20% of the disputed tax amount. No, disputed demand, including the earlier payments made, if any, by 15th February 2023. No coercive steps will be taken against the petitioner. Stop. All right. Yeah, disputed demand bracket excluding penalty bracket, but including all earlier payments. All right. No coercive steps will be taken against the petition. The impugned order stands modified accordingly. The petition is disposed of.
Item number 12.
May I please, Lordship may kindly turn to page 46 of the brief minutes. This is a notice under section 148, my lord, for the assessment years 14-15, my lords. And even though the date has been shown as 31st of March 2021, which is the last date of limitation, my lord, my humble submission, my lord, it was served on 1/4/2021 after the new act has come into place, my lords. But this particular issue, my lord, was before your lordship's court in Nutan, my lords. And this involved assessment year of 13-14, my lords. And your lordships have dealt with Ashish Agarwal and also the question of limitation, my lord. And your lordships have passed necessary orders.
Permitting them to initiate fresh proceedings.
Permitting them, my lord, to initiate a proceeding, my lord, under the new act, my lord.
Your lordship kindly have a glance in notice and the last line, date of service, time of service.
So that is not the time of service.
Yes,
that is the date of generation, my lords.
That is not date of because you indicate solve, my lord.
No, that is
last line.
Lord, my lord, in many occasions, your lordship have seen, my lord,
And
the date of generation is one. Your lordship, generation of the date of generation is one. Services another, my lords. And it is issued and served, my lord, the next day, my lord. That's my specific. And the revenue, my lord, does not, my lord, suffer because they have to only give me a chance as per the new act, my lords. And I have a proceeding, my lord, as per 148A, my lords. And I'll be able to demonstrate before your lordship, my lord, that the entire income, my lord, does not fall within the definition, my lord, of income, my lord, as envisaged under section 224, my lords. Here, my lord, the entire amount of tax has been paid by the HUF, my lords. Now, my lord, is being allowed. Now, my lord, is being sought after. The individuals are being, my lords, taxed.
No, but Newton will not apply because Newton is not a case of late service.
No, my lords, your lordship may. For your lordship, may just say that since it is the let them follow the procedure. They are not prejudiced.
He has to first ascertain when it exactly.
Let my learned friend take
because
instructions.
He has not produced any document show for a date of receipt. He has only averred.
But I can't. I can't. I made a specific government. If my lord, if my learned friend wants,
how will that get?
Yes, that is what.
My learned friend may take instructions in this matter, my lord. My specific government, my lord, it was never served, my lord, on the date shown, my lords. It was served on the next day. It was issued, my lord, on the 1st of April, my lord. Your lordship as a test case.
I'll take next to your lordship.
Mr. Khare states that the impure notice under section 148 of Income Tax Act 1961, although dated 31st March 2021, and shown to have been printed out as per the date and time stamp at 5:24 p.m. on that date, was in fact served on the petitioner SSC only on 4th January.
1st of April.
Oh, sorry, only on 1st April.
April 2021.
1st April 2021.
Issued and served.
No, issued is not clearly mentioned. Issues cannot be.
Okay, my lord, I
was only served on 1st April 2021. Full stop. Mr. Satpathy, learned senior standing counsel of the department, needs time for instructions. The relevant record we produced on the next page. We produce a record
My lord, digital electronic record, my lord, I will take instruction because it was faceless, my lord. So it is
To cut.
No, it's sent by email.
that is what, my lord, I put date of service and time of service.
Yeah, he seeks time to verify the record and inform the court
Yes, sir.
of the precise date and time of service of the notice.
Yes.
May I plead for no coercive action till then.
What course of action is that?
No, they,
Next to your
let's
lordship.
the
Next to your lordship.
March, my lord, your lordship, no, my lord.
Yeah, 1st February.
Till then, my lord, it is no course.
No, nothing.
Lord, your lordship may protect me, my lord, otherwise.
What will happen? Nothing will happen, Mr. Karan. All right.
Item 13.
Well, may it please your lordships. The faceless assessment, admittedly, there is a variation prejudicial to my interest. Your lordships have held, my lords, that the draft assessment order along with the show cause notice is to be supplied. This has not been supplied in this case.
All right.
Lord, I have taken instruction so far as because lordship see the page 36. Though, my lord, it was not draft assessment or not that has taken instruction, but the variation has already been referred in the notice.
That may be, but you have to prepare a draft assessment.
Your lordship, I have taken instruction.
One of the contentions raised by Mr. Ashok Parijala and its senior counsel, the petitioner, in the present case is that the mandatory requirement of
144.
submission of a draft assessment order under section 144 capital B of the Income Tax Act 1961 has not been complied with. It's a notice, Mr. Satpathy accepts notice for the department and seeks time for instructions on the above issue. No coercive steps shall be taken till the next date. I think same date, 1st February.
Lordship, please.
Right.
Item 14.
Item 14, my lord, infructuous.
All right. Dismissed as infructuous.
Item number 15.
There are the 3 cases which are left out, but has been clubbed. The other one, your lordship have posted it to 10th of, I'm sorry, I did a copy calling. 10th of May. 10th of May, madam. May I pray your lordships? I've got sorry, my lords. I have only one copy, my lords. I'm extremely sorry. And the other. This may be revived.
No, but there was no interim order. Was there an interim order?
Yes, interim order was there, man.
Yes.
Interim order was there.
In the review petition, that put down review petition, it is now urged by Mr. Siddharth Rai, like that the present petition is not covered. Why is it not covered, Mr. Rai?
This is
Well, it's too much of natural justice. In Tarni, same.
The notice again issued.
Again, where is the statutory power, my lords? I may request several times, but you have to act. You are a creature of the statute.
Information.
You are not.
That
Yes.
in complying the natural justice, my lord.
Yes. So what? You cannot go on extending your own latches. You are hiding your own latches. You are unable. Same.
Lordship's order.
Yes. Same reasons. No, the question is my lords. I was thinking right from the beginning whether I am safe or not today. But, beg your pardon? Here, my lords will kindly see. And the case I think this court will not be disparity. There cannot be any disparity. One same service. Other dining space. On my request,
disposed of yet, so they will await.
Yes,
what we're saying today.
No. Lordship may fix it to 10th of May. Also, and you are a creature of the statute. You go on extending 2021, 2022, 2023 on my request. You are a creature of the statute. You have to act within the bounds of the statute. As a statutory limitation, and I have to plead that. As per clause D to 148A. Lordship may fix it to 10th of May. My lords, my humble prayer before your lordship is.
What we'll do is we'll just fix the review petition itself.
Yes, sir. Okay. Revive the file, my lords.
Okay, list on 10th May 2023, along with writ petition civil 23354 of 2023. All right.
An interim order to continue. That interim order is there.
No. Yes. Review, there's nothing, sir. Review, there's nothing.
Review?
In the review, there can't be interim order.
No. What I say, my lords.
You're not recalling. We're simply placing the review petition itself with that.
My lords.
All right.
At least let him not proceed because it will become infructuous, my lords.
Let's see. We don't know what he's going to do. All right. They'll come up with something new for you to latch on to. All right.
Item number 16.
This matter is similar to yesterday's item 32. WPC 36,528. Similar matter.
When is it coming up?
No, it is not uploaded. Yesterday's item 32.
The objection has already been dealt with, and annexure 4 is the.
That is there said general in nature, and now it has been pending before the government. Lordship yesterday directed government to consider the objection.
The same order.
Yes, item 32.
Okay.
Yesterday's
same order is yesterday's item 32. All right.
WPC 36,528.
Okay. 36,528. All right.
Item number 17.
May in this petition made innocuous prayer, they have made repentation before OP number 1 regarding bypass road in Pavisurja Nagar, my lord. Let the OP number may consider.
All right. The petitioner's representation, bracket annexure 8, shall be examined by collector.
Yes, my collector. Chief Secretary.
No. For a road, sir.
Collector
Ganjam. And after notice to the petitioner and giving them a hearing, a reasoned order shall be passed not later than 10th April and be communicated to the parties within a week thereafter. Petitioners within a week thereafter. Court clarifies it is not supposed to be.
Item number 18.
I have filed a representation pending before opposite button of 3, my lord. At page 28. Let the authority.
My lords, there is no acknowledgement or postal receipt.
Yeah. That's the whole problem, sir. There has to be some acknowledgement, postal receipt, something, permitting the petitioner to make a fresh representation to the authorities, and after obtaining proper acknowledgement and following up on such representation, to seek appropriate remedies in accordance with law. The petition is disposed of.
Item number 19.
Permitted to renew my prayer?
Yes, all that.
Item 19.
None appears for the petition.
Item number 20.
May I please, Julius? Here is the matter, whole controversy, whether the service we rendered, whether it's coming under GTA or not, my lord. In this background, my lord, page 21 of the order of assessment is relevant, paragraph 5.6, my lord. Here is the adjudicating authority is not sure that whether he is coming under GTA or not.
All this is subject to appeal, sir.
My lord, only fact that I am neither service receiver or service provider.
All you raise
they
is
will have to. They have to made a demand in order to deposit the 7.5% in appeal proceeding. So if he will set aside the matter, again date, fix any date, he appear there and again apprise the authority. So to that extent, my lord and brother, I am requesting him, if it is like that, a man can be saved. Because 67 lakhs demand, my lord.
Court fee 6.5 rupees.
67 lakhs is demand.
No, and that's what. By paying 6.5 rupees, you want to avoid pre-deposit of 7.5%.
7.5% deposit.
It's a good calculation. From the purely business point of view, an excellent proposition. But from legal point of view, it's a problem.
Well, whether the assessment is not sure that whether you coming under GT or not, he make an assessment on hypothetical basis.
All right. Counsel the petitioner seeks leave to withdraw the present petition with liberty to file an appeal as provided under the statute in question. If such appeal is filed not later than 1st March, accompanied by an application for condition of delay, citing the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority.
Well, no course.
The court clarifies that it is not expressed.
Till filing of the appeal.
No.
No, till
There
filing
is,
the
this is
appeal, my
the
lord.
first time it's coming up, sir. We never passed an interim order for it.
Item 21.
For opposite party number 1 to 4.
Yeah.
Okay.
Item number 21.
May I please, Your Lordship? Your Lordship, the petitioner has challenged the order under Annexure 1. So, Your Lordship may kindly come to page number 4, second
This is the
paragraph.
COVID thing.
Pardon, my lord?
Condoning delay on ground of COVID.
Yes, Your Lordship. So,
We've
Your
already
Lordship,
passed those orders. I think a long judgment has been given by Mrs. Raman. You have the judgment?
Your Lordship, it is annexed on Annexure 2.
No, that is Supreme Court.
There's a judgment on this COVID orders of the Supreme Court.
Your Lordship, Supreme Court order is annexed here.
So that's practically go back. You say the second appeal of the petitioner was dismissed by the Orissa Sales Tax Tribunal only on the ground of delay, not accounting for the order dated 10 January 2022 of the Supreme Court of India. In suo motu writ petition CLP 3 of 2020. That view of the matter, the impugned order dated 9th September 2022 of the tribunal is set aside. And essay number 25 bracket ET of 2022 is restored to the file of the tribunal to be decided afresh by first dealing with the issue of condition of delay in light of the above order of the Supreme Court of India. The petition is disposed. The appeal will now be listed before the tribunal on 20th February 2023. A copy of this order be sent to the tribunal forthwith. The writ petition is disposed of the above.
Grateful, Your Lordship.
Item 22.
Yeah, please, my lords. Here the petitioner, my lord, is a petrol pump owner, my lord. And originally the oil company, my lord, was supplying petrol.
Your Lordship, it is the consequential order of that show motor revision appeal. And that original writ, Your Lordship, has been adjourned to 2nd March. So let this matter be tagged with that matter.
Your Lordship, just permit me, Your Lordship may kindly turn to page 56. The so motor, or this is the so motor, in the revision, my lord, my application was allowed. Then a so motor proceeding was initiated by the commissioner. The commissioner, my lord, deferred with the order of this revisional authority and struck it out. But while doing so, he has said that the same is accordingly set aside. The word set aside, my lord, now is being interpreted by the additional commissioner as if, my lord, is sent back to him for a fresh order, my lord.
Okay.
Then your Lordship would see, my lord, page 57, you must see. This order has to go. Your Lordship would see. No, Your Lordship will kindly turn to page 56.
It's set aside.
While saying that he does not agree with the revisional order, hence the same is set aside. Then Your Lordship may turn over the page, my lord.
Your Lordship, I'm accepting. I'm not disputing. Your Lordship only reason is that today, if Your Lordship will pause this, but that order remains. In that order, against that proceeding, Your Lordship has directed to file counter. So I am just saying, let it be there along with that petition so that
unnecessarily multiply, my lords.
Well, let me take instruction on this issue.
Page 13. Page 13.
Your Lordship, no consequences, Your Lordship.
No. I think not remain at all.
I think no consequences. Your Lordship, because in that order, Commissioner in Somoto revision has stated that the registration should be granted from that day, this day. By declaring the order passed by the revision is illegal. So it is that consequential order to the Commissioner's order. So Commissioner's order is there.
I have just given
Commissioner's order is there. If at all, it is the consequential order of the Commissioner's order.
And the Commissioner's order is before Your Lordship. And for the word set aside, my lord, I have extracted the meaning at page 13 of my brief. Your Lordship may kindly see this. Your Lordship already knows it at paragraph 26, my lord. According to my lord, Black's dictionary, my lord, the word set aside is reverse, vacate, cancel, annul, or revoke a judgment or order. So this can't be, my lord, demanding again, my lords.
The challenge in the present petition is to an order dated 26th October 2022, passed by the Additional Commissioner. Of Sales Tax, Central Range, Jashpur Road, Jashpur.
And in this entire proceeding, the petitioner appears himself. The petitioner appeared. It is the order.
What option does he have, sir? He's being called to appear, then he'll appear.
Your Lordship, he has appeared and filed submission. Everything has been filed and
No, there's no waiver and estoppel in this. Hello. Rejecting the revision petition of the petitioner. Whereby the
Page 50 and 51 of the revision order. That was
request for issuance of Form C for the quarter ending March 2019 to March 2020 was rejected on the ground that
No, Lordship, that order is there. Revision order, Your Lordship, I may be.
the original, may I just clarify, the original revision permitted me to get those C forms. It was taken up so moto and the commissioner says it can't be done because your registration is afterwards. Lord, while doing so, my Lord, he uses the word, hence the order is set aside. Now that word set aside, Lord, is taken up again as if it is set aside again to the additional commissioner. And the additional commissioner again repeats the same order, Lord, of the commissioner, that it cannot be given.
No,
and it treats this to be a set-aside assessment, a set-aside revision.
Your Lordship,
so once this main order of the commissioner denying the benefit is before your Lordship's, my Lord, challenged. So this particular order, again, reiterating the commissioner's order by the additional commissioner.
May not go to the merit of the case because the merit of the case is there. Your Lordship, for that reason, since it is for the first time listed, so I have let both the matters be tagged because I am filing counter there. Your Lordship has directed. Only the dispute is that with from
that
which
order itself is under challenge. When the order set aside order is under challenge in this court in a separate writ petition.
Your Lordship.
Where's the question of this person again entertaining another suo motu revision and passing order?
Suo motu revision.
It's a set aside.
It is not suo motu revision, Your Lordship. Your Lordship, I may not convince you. Your Lordship, what happened here, Your Lordship, there was an order rejecting granting the application for registration from certain date. The petitioner filed a revision application under section 79(2), an application of revision, Your Lordship, by praying with a prayer that the granting of registration date should be prior to 1 month. Your Lordship, from the date. And but the revisional authority has allowed that date. Against that order, suo motu revision has been done. Against suo motu revision, the order of the revisional authority has been reversed, Your Lordship. And there, in the suo motu revision, there the commissioner has written that the effective date should be this and hereby set aside. The revisional order is hereby set aside.
That has been challenged in this court, pending in a writ petition.
That is pending on merit.
Right.
On merit, Your Lordship, from which date the registration should be granted.
Right.
Your Lordship, that part is there.
Right.
And against that set of original revision, the revision filed by the petitioner. Your Lordship, that since the revisional authority is on view that it has been set aside by the commissioner in suo motu revision, thereby an order has been passed. It is only the consequential order. It has nothing to say.
The word set aside cannot be remanded.
After 2 orders will be there.
No, it is the consequential order of suo motu revision.
There's no consequence at all. It does not remand the commissioner to the
I have no grievance, Your Lordship. Your Lordship,
why are you going on arguing?
I'm saying simply that Your Lordship may not go to the merit of the case. Only prayer.
I have to note in what context. Should I simply say one line? The impugned order is set aside. Will you be happy?
No,
I will say counsel for the standing counsel does not permit the court to describe the background facts.
I'm sorry, I'm no.
You're not letting me even speak the background facts.
I'm sorry, that is not my intention.
Yeah, I only dictated in what background the order has been passed. You're saying, no, don't discuss the merits. We're not discussing merits at all.
I'm on the premise of you that your lordship.
You're over anxious. I don't know for what.
I'm sorry. I'm sorry.
Maybe we'll dictate it separately in the chamber. Otherwise,
No, Your Lordship. No, Your
go on
Lordship.
interrupting.
I'm
You
sorry.
wasted 5 minutes for nothing.
I'm sorry.
You just say the writ petition is allowed, the impugned order is set aside, detailed order will pass in the chamber. All right.
Obligement.
Your Lordship, I'm sorry.
Item number 23.
May I please, Your Lordship? This is with regard to my lord claim of exemption of excise duty and fine during the COVID period. Your Lordship has been pleased to entertain matter and grant interim protection to the respective parties therein, directing the matter to be listed on 1st of February for consideration. If Your Lordship permits me, may I pray, my lord, similar kind of benefit may kindly be extended to me. My lord, with Your Lordship's permission, I am producing the order, my lord, for Your Lordship's kind perusal. Your Lordship may kindly peruse, madam. I have given a copy to my respective senior appearing for the state also.
On 1st February, matter is listed. I have to file.
Your Lordship has been pleased to call upon the state to ask.
Right. Say notice, the accepts notice, list on 1st February along with petition civil 162 of 2022. Till the next date, no course steps will be taken.
169.
169. Yeah. Till the next date, no course steps.
Deeply grateful, my lord.
Item 24.
24, my lord, kindly taken up next week, my lord, on behalf of Miss Chitrapad. She is not well.
Let's see what the
Suffering from throat infection.
list on
Hashtag?
21st February, defects be cured.
Oblige, my lord.
Item 25.
Item number 25 to 40. All these matters are relating to that case of Sarat Parida. Your Lordship, similar or
they've all been served.
No, opposite party in the item number. Item number 30 and 31, the respondents appeared. On other matters, notice has not yet been done. At the first date of in admission in the
Who's appearing in what item numbers?
Item number 30 and 31, the respondents appeared. But in other matters,
who's appearing, sir? 30 and 31. Sanjeev Kumar Rathore.
Item 30
and 31.
31.
You'll have to wait for them because the board is not working even now. We'll pass it over. Let's see if that person comes. If he's himself appearing for the others, then we can dispose of everything.
but before the Honorable Single Judge, he was not the counsel. Your Lordship.
What was it?
And 33 is different only.
33 is different.
33 is different.
What is 33?
33 not pressed.
33
not pressed.
Dismissed is not pressed. 33. The remaining passed over.
Item 34.
No, 34 only. 40 he said.
Up to 40. Up to 40.
Supplementary list item 41.
May I please, Your Lordship? Just given small notes because some facts are required. But before that, I may tell Your Lordship the dispute. I am for the.
Then we take it up at the end of the board because who's for the opposite party?
Last time, Mr. Advocate General appeared. I am not sure. Last time.
So we'll pass it over there.
Will Your Lordship take it up 2 p.m.? Will be convenient or what time?
End of the board. Normally we take it up at the end of the board. If you're not available, we take it up at 2 p.m. We'll right now simply pass it over. When it's called out again, if you are not there, we will take it up at 2 p.m.
Item 42.
My Lord, on behalf of Mr. P.K. Satpathy,
No instruction, my lord.
Your Lordship, dismiss this matter. I am appearing for opposite party number 4, SEBI.
All right.
My lord, I am to the petitioner, my lord. I am to the petitioner on behalf, my lord.
Sorry?
Item 42, my lord. I am for the petitioner.
Then what is he?
My lord, WPC number 15467 by 13.
11861 of 13.
That's a tag. He's the third. Okay, the third matter, 15467. Manoj Kumar Mohanty, you say counsel the petitioner states that he's not pressing the matter. Dismiss is not pressed. Which a precise matter in which are you there?
11861.
Who's okay? We'll call out each on the who's in 12764. 12764. None appears to the petitioner. Dismiss not prosecution. Then 19033.
19. Yes, my lord.
You're there.
Yes, my lord.
All right. Yes, sir. Tell me. 11861. Tell us what is the matter about.
My lord, this is a matter challenging the inaction of the opposite party with regard to the misappropriation of fund by the Orthodox group of companies, my lord.
Sir, with regard to the?
With regard to the collection of money they have collected through different schemes, my lord.
This is all private individuals.
My lord.
Why should a writ petition be entertained? This is a private company, sir. Multi-state credit cooperative society.
It is registered as a multi-state cooperative society, my lord. By the Central Registered Cooperative Society, Government of India, on 29/9/2010, my lord. They have taken money on the
have you filed criminal complaints?
Contents, my lord.
And then there is an OPID Act also, no? You have all those remedies. No, when? Which year then? When have you filed the petition?
My lord, this was investigated by the UOW, crime branch. First, then the UOW. Crime branch, then handed over to the EOW, Economic Offence Week, letter to CBI. The case has already been investigated upon, and the first charge sheet has already been filed.
Then you pursue that, sir. The court is informed that the CBI investigated into the complaints of the petitioners, and a charge sheet has also been filed, and the criminal case is pending. In view of the above developments, the court is not inclined to entertain the present petition to grant the reliefs as prayed for. It will be open to the petitioners to follow up the criminal proceedings and thereafter seek appropriate remedies in accordance with law.
I am for the opposite party number 4, SEBI.
The petition is disposed of in the above terms. In the other matter, you say in view of the order passed today in 11861 of 2013, the present petition is also disposed of in the same terms. All right.
Obliged.
Item 43.
May I please,
My lord, this case is filed by my lord Justice Raman.
I list before a bench of which Justice Raman is not a member. On 1st May.
Item number 44.
These are all matters will be covered by a lordship judgment, except one small variation. In the middle matter, my lord, this item number 44, the first one will be covered, third one will be covered. This middle 20602 up to 2014. Here, my lord, out of the total land claimed, state has acquired 700 decimals of property from this land, and they have awarded compensation. That compensation deposited in the court. For the purpose, I am taking separate steps. But residual part of the land, your lordship judgment will cover. That may be only clarified. But I have filed a writ petition for that also. There is an order to that effect by the honorable single judge. Only 700 decimals out of the leasehold land is acquired by the state. And that's a dispute before the competent court in the land acquisition authority. That's pending. Who receive compensation because that was awarded in the name of the earlier persons. Since we are the purchasers, we are claiming over that.
No. So what is the order to be passed in 20602 then?
Lord, that will cover except the lands acquired by the state for the purpose of construction of a road. Rest of the properties are intact. The same judgment will cover.
My lord, it is a common judgment your lordship has passed. So that direction will follow. If some portion of the suit land is already acquired, that will be automatically excluded.
All right. In two petitions, that is 20956 and 24783, we say following the order of this court in Narottam Ratha, the state of Orissa, the impugned order of the ASO is set aside and the two directions. In writ petition civil 20602 of 2014, you say Mr. P.K. Rathal under counsel for the petitioner informs the court at the outset that of the total land involved in the present petition, a portion has already been acquired by the government of Orissa. And it is only in respect of the remaining land continuing to be in possession of the petitioner that an order request be passed with this court following its earlier order in Narottam Ratha, state of Orissa, Supra. Paragraph. Taking note of the above submission, the court directs that as regards the land which is remaining with the petitioner, that is excluding the land taken over, acquired by the government of Orissa, the impugned order of the ESO will stand set aside and the following direction submission.
Now, with regard to acquired land, let me kindly clarify one sentence. I'll take steps in the appropriate court to get my compensation.
Mr. Ratha states that as regards the acquired land, he will take steps in the petitioner will take steps in the appropriate court for release of compensation.
That's it.
Right.
Item 45.
Item 45, item number 45, my senior is not well. Let it come next week, madam. Item number 45. My senior, Mr. Mahad, is not well.
5, 6, and 8. GLS. This is not one of those 7B3 matters.
No. It is schedule area regulation 2.
Mr. Manthi, learned counsel appearing for the senior counsel appearing for the petitioner state to be unwell. List on 13th April interim audit cut.
Item number 46.
My lord, it may pass over. It's Satpathi's election other.
Pass over.
Item 47.
The memo statement record dismissed as infractions.
Item number 48.
Your Lordships, this is the second round. We actually are only concerned over that community center that had come up near the hospital, and there is a toilet, and it was built under the government scheme. Evidence is under Annexure 1 and 3. So what really happened is the petitioner.
It's after notice, isn't it?
Yes.
They haven't filed a reply.
Yes.
We'll take some time to file a reply.
All right.
For the OP number 5, I have already entered appearance.
But you also not filed a reply. Replies we filed within 4 weeks.
Lord, if I make a submission of a sentence, I think my learned friend's grievance will be raised. C, challenging the collector's order precisely on the ground that no opportunity has been given to them. That should be the ground. There are two aspects. The collector's order is revisable by RDC. That is one. Two, if the natural justice point is taken, parties to be relegated back to the collector for a fresh hearing. And
Lordships, if Annexure 11 is set aside, that 11 and the order under.
All right. The matter is coming up after notice, despite notice having been issued on 21st December 2022. None of the respondents, opposite parties, have filed a reply. Stop. Paragraph. The short question and short ground in which the order dated, the notice dated, is it?
Order.
Your Lordship. No.
Page 40. That's an order passed.
That's an order after your
the order dated 10 November 2022 of the Collector Jashpur in Miss Case number 65 2022 has been challenged is that the present petitioners
Some of the encroachers are evicted, some residual encroachers are remaining. For them, this order was passed.
No, Your Lordship, it's a little different. No, I'm saying that all of them who are there under Annexure 11, all of them can be heard, because in pursuance to that order, various notices have happened now, which is under Annexure 11. So all of them may be heard, otherwise they'll again come before Your Lordships. So for the closure of the matter, everybody who's under Annexure 11 can be heard.
Let them.
No. What is your locus?
Your Lordships, I have been noticed. I am at that community center. So there's an youth organization which runs the community center. So I'm the head of that, because of which I was noticed. That community health center is beside the hospital, and there's a toilet which came up to meet the needs of the local people who come to that hospital. And it's built under the government scheme. That report is there also. That's built under. So we don't want, when this order was passed, they thought it's just like any other club which is on the government land. But no, government actually has set it up, and all the eye camps happen there. When there's floods also, people take shelter there. So that's why we came before Your Lordship that they should not evict us or demolish this, and that we have not been heard. That's the...
So you're running the center, is it?
We have promoted it and said that, let the center come up. It's just beside the PHC.
Let the public take a call on that.
The petitioners who run a community center next to the primary health center.
Primary health center. And a toilet also. Under the... Milap.
And a toilet have not been heard before the said order was passed. Paragraph. Mr. P.K. Rathore, learned counsel, appearing for the opposite party number 5, does not dispute the above fact. So he states that an appropriate order can be passed requiring the collector to redo the entire exercise of passing a fresh order after hearing all the necessary and proper parties, including the petitioner. Paragraph. In that view of the matter, the order dated
10th of November
2022, passed by the collector Jashpur in Miss Case number 65 of 2022 is hereby set aside. And the aforementioned Miss Case number 65 of 2022 is remanded to the collector Jashpur for a fresh hearing and decision in accordance with law. The matter will be listed before the collector Jashpur on 1st March 2023. The petitioners will appear on that day together with a downloaded copy of this order, as will opposite party number 5. After hearing all the parties, including parties to whom earlier notices were sent.
Yes, Your Lordship, all that is there under Annexure 11. Fresh notices have been sent. 11.
The collector will pass a reasoned order disposing of the said case within a period of 4 months thereafter. The court clarifies it is not expressed anywhere in the matter. Till that date, status quo as of today shall be maintained. The writ petition is disposed of in the above terms.
Item number 49.
49, my lords, for BMC, I only pray further 1 week time may be granted, we'll file our counter. It's almost ready, my lords. Because of the management in Hockey World Cup, all staffs are engaged. I pray, my lords, 1 week.
Next 2016 matter, sir.
16 in 2022, we have appeared, my lords, August.
Last opportunity to the BMC to file its affidavit on or before 1st March 2023. Rejoined before the next date.
Other opposite parties were also directed to serve copies of their counter affidavits so that BMC
counter affidavits of other opposite parties also be served on all other parties as well. Second May.
Item number 50. Item 50.
None appears dismissed.
Item number 51. Item 51.
Read out the name.
WPC 167/5/20. Priyadarsan.
Lordship, respondent are filed the rejoinder, wherein they have placed the document which is absolute, or during the hearing of the court, they have created a document to defend the case and taken only 1 year to file this document. And it is still under challenge whether it is sanctioned by the government or whether it is prepared by a administrative officer. Lordship, therefore, I have invoked the 340 of CRPC. They have made forgery in the document.
September. Is it 2111 affidavit? So that affidavit dated 21st November. That is the affidavit you are referring to, 21st November. When did you file it?
They filed it 22 September.
Exactly, that should be 21st November. I think it is filed by us in 21st November.
Oh, you filed the 21st November affidavit?
They filed.
They filed. That's what
I have filed a rejoinder and application under 340 of CRPC.
That's.
You seek instruction, I have not received yet.
Let's say in 340, they have not required to file any year. This is the honorable court is take cognizance whether the documents are prime facie is a forgery or they have made a false statement.
So then you have to give answer.
Let's say rejoinder application page number 17. Please consider page 17. It is the office procedure manual which they have followed, wherein 58 standing guard file, serial number 58. A rejoinder application, page number 17, serial number 58. Lordship, when a standing guard file is prepared, there should be a government decision. Government decision to communicate the citizen of India, they have to notify the Gazette notification. Gazette notification itself not a government sanction. They have totally crime, white collar crime it is. It is a white collar crime. They have only published a Gazette notification and drawing pay and pension and their rank status. Where a employee is Group C employee and by a Gazette notification he becomes a Group A employee. It has no government sanction. Allow me to explain how a government rule is published and how it is passed in both houses of parliament. There is a parliament procedure.
One minute, because this will take some time. We'll take it to the end of the board.
May I pray, my lord? May I pray? A lot of allegations is there, as well as
speak in the mic, sir.
Lot of allegations there. Apart from this, he specifically averred in the paragraph 10 that it was document was forged and it was created. There is my instruction that the cabinet secretary is a party who look to file application for deletion of the name. Thereafter, Lordship may hear it. So Lordship can give another 4 weeks time. In the meanwhile, rejoinder filed by him. Already I obtained instruction. Very shortly we will get the instruction. Then we will play.
Lordship, they have
because he is working in the army and filed the PIL and got the document.
So, citizen of India, it is not mandated.
But it's that locus of the petition also and is a question. So Lordship may keep it after 4 weeks any day.
Lordship, it is already taken 1 year and they have to seeking time.
They have filed the rejoinder
because of what you have said in your rejoinder.
Lordship,
because of what you have said in your rejoinder, he needs time for instructions.
Lordship, they have filed for the respondent for all. They have filed for the cabinet. They have mentioned it. They have filed for the cabinet.
No. What you have said in your rejoinder, he wants to verify, sir.
Lordship.
Counsel, Mr. Padil, Deputy Solicitor General of India seeks time to take instructions on the rejoinder filed by the petitioner, in which certain amendments have been made, which require, according to clarification. Yes. So, at his request, list on. March.
Lordship, they should serve in anything document in my email.
Yes, sir, there is a mail ID is there. You can send it. No issue.
Item number 52.
Press your notes.
Item 52.
Lordship may reflect along with Mr. Kashyap is appearing. Lordship may reflect.
Press your notes. Sorry, not press. Not press. Dismiss is not.
Lordship, the appearance of Mr. B. Rautray for opening number 5 may kindly be recorded.
All right.
Good.
Item 53.
May I please the Lords? My Lordship, I'm appearing virtually. My Lordship, at the last date, the pleadings were closed for this case and today it was kept for hearing. If my Lordship permits, I may submit virtually.
You are ready with the matter?
The rejoinder affidavit which my learned friend had filed, I have sought for instruction that has not yet been received.
But please don't file any further affidavit.
No, only instruction I need, because all the aspects had been described in the counter affidavit. Only 2 grounds she had made in this rejoinder affidavit. On that point, I have sought for the instruction. Only instruction will do.
Mr. Mahapatra states that he needs to seek instructions on 2 aspects mentioned in the rejoinder affidavit. He assures the court that no further affidavit will be filed by the opposite parties. At his request, list on 24th April, sir.
Right. Item 54.
May
I please your Lordship? This is a PIL filed by the Sarpanch of Gram Panchayat on 2 grounds, my lord. Because it's a scheduled area, section 27 requires the mandatory consent of the concerned Gram Panchayat. Here, in response to public notice, they have filed the resolution objection and the resolution not to allow any on-shop in their area. That has been never taken into consideration while issuing the license in favor of OP number 5. Another aspect, my lord, the OP number 5 is the employee of liquor manufacturing company. 37 also puts embargo. So in this circumstance, I pray all the matters should be remitted back to the Lord Secretary to look into all the matter, because all the voluminous documents. This year also we have filed our objection on the way of resolution for 23-24.
Madam, I am appearing for the OP number 5, Lord. I have last occasion I have sought for filing of counter, but just a few days back I have received the instruction of documents.
Okay.
And I also require
for opposite party number 4 states that he will positively file the reply affidavit.
5, Lord. OP 5. OP 5, Lord.
5. Filed reply affidavit on or before 1st March 2023 with an advance copy to counsel petitioner, who's permitted to file a rejoinder thereto for the next date. 25th April. No, 26th April. Sorry. 26th April.
Item 55.
Your Lordship, item 55, Your Lordship. I'm appearing on behalf of Mr. S. Rathore through virtual mode. Lordships, in this matter, Lordship may pray for 2 weeks' time to file rejoinder. The problem remains the opposite party have filed their counter in 29 June 2022. But the problem is, Lordships, the company has shifted its management to Singapore. So it's taking some time to Lordship taking it.
Rejoined to be filed for the next date. List on 4th July.
I am for the opposite. List, my lord.
Item 56.
May it please your lordships. My lords, after 9 years, at 10 p.m. yesterday, a counter of 50 pages was served.
All right, rejoined to be filed for the
identical matters. Your lordship, this is the process tax. Identical matters have been
Not identical matters. I am totally against this identical one. Totally. And I'll prove now. I am totally against this identical.
All right, anyway,
I will
keep it on a separate date.
Yes.
He wants to file a rejoinder.
Yes.
All right, rejoined to be filed before the next date. List on 5th July.
5th July. Interim order is there, man.
All right, interim order to continue.
Much obliged.
Item number 57.
May it please your lordship.
Just 1 minute. In 56, all those applications, that refund and all, I don't know. What are these applications?
No. These are.
No, lordship, that refund is that pursuant to this honorable court at the time of admission has directed to pay certain amount. And
that has been paid.
And that has been paid. The petitioner has filed a miscase that
So
in
that-
case the petitioner
That is a gamut. That's a gamut to earn some money. Finally, very frankly.
All right, on the next day we'll take.
Yes.
All right.
57.
May it please your lordship. Milord, I'm on virtual mode. Milord, your lordship was pleased to, this is a matter under the OVAT Act. Milord.
Correct.
The lordship was pleased to refer the matter to the concerned roster bench on 6/9/2022. Milord, your lordship
Correct.
sees that order. I'm constrained to make this submission, Milord, and I deeply apologize for the same, Milord. Honorable Justice Raman, Milord, while sitting with Honorable Justice Jaswant Singh, was not inclined to hear the matter, Milord. Because in September, that was the concern, that was the roster bench.
All right, let's move for a bench of which Justice Raman is not a member. On 24th March.
As your lordship please. May I pray that the interim order be continued till
interim order to continue.
I'm deeply obliged. I'm sorry I make this submission, Milord.
No.
It's my duty to point it out. I'm obliged.
Item 58.
Item 58, the matter has become infractions.
Okay, dismissed as infractions. The memo is taken on.
Item 59.
My lord, in item 59, I'm appearing through virtual mode. But today I have instruction to appear in this matter because Mr. Mishra has joined the government side. Lordship may give me some time to prepare in the matter, madam.
All right. Mr. Mohanty, who appears now for the petitioner, seeks some time to get ready with the matter. At his request, list on 5th July.
Lordship.
Item number 60. Item 60.
None appears dismissed.
Item 61.
61, Milords, is what I was mentioning in the morning. Milords, 61, I'm challenging the rejection of my request to give me certified copies of the order sheet and the search warrant.
You not filed a reply here, right?
Yes, they have filed a reply. They say, Milords, that the investigation is not over. Therefore, we cannot give the certified copies. Now, Milords, that is a very fallacious submission, Milords, because if the investigation is not over, then you couldn't have issued the show cause notice. If the investigation is over only, then you issue the show cause notice. So therefore, Milords, I have filed, Milords, on the basis of their judicial admission in their counter affidavit. Milords knows that the judicial admission is the highest form of admission. On the basis of that, Milords, I have filed 2 writ petitions, Milords, challenging the show cause notice itself because it is premature on the basis of their very admission. It is premature. So therefore, Milords, I pray, Milords, those 2 writ petitions, Milords, I give the memo once again, Milords. Your Lordship may kindly call all these matters together, Milords. That's what I pray, Milords.
All right. Mr. Acharya states that the present petition may be listed with 2 other
WPC's
writ petitions, that is WP Civil 799 and 800 2023. Paragraph. List the present petition with the aforementioned writ petition civil 79 and 80 of 2023 on.
Can it be tomorrow, Lords?
No, Lord, I have to take instead tomorrow after possible. Next week, Lordship. Next week.
18th. Next.
28th February.
February, Lords.
28th.
Yes, we have to respond.
I think this will not get over. Before that, I think the proceedings are still going on, right?
Mullahs, the show cause notice they are proceeding with.
That's right.
And
so let the proceeding go on. I don't think it will get concluded in this month.
Then, Mullahs, that may be observed in the order, Mullahs. That's what I'm saying, Mullahs. I am not, on one hand, I am being incapacitated by not being handed over my own.
In the meanwhile, proceedings pursuant to the show cause notice can go on, but no final order shall be passed. All right.
Mullahs, grateful.
Item number 62.
62, Your Lordship, it may be withdrawn.
Dismiss is withdrawn. All right.
Sorry. Item 63.
These are all active cases. Could your Lordship kindly take up my missketch which will clarify the facts? Lord, that is our flag C, man. The short point here would be, my lord, flag C annexed 5, page 5, your Lordship may kindly say I have given a detailed chart. Lord, prior to 2017 rules, MGQ was being fixed monthly basis. Am I clear, madam? On monthly basis, MGQ was being fixed, licensee is to lift it. But collector has the power, in case of short lifting of MGQ in a particular month, he will grant permission to lift it in the subsequent months that goes up to February. But 2017 rules, they have made the MGQ annual basis. Throughout the year, by end of March, the entire MGQ, irrespective of lifting in any month, can be lifted, madam. Now, I have given a detailed chart. Of course, it is prior to the amendment. I have said that your monthly MGQ, the total yearly MGQ, I have lifted much beyond that. Even excess I have lifted and I have paid. I have given the chart, my lord, kindly. And that is what the collector had also permitted me. Kindly see that chart, my lord. If the chart is taken note of, I think the state cannot have a demand. After 11, 12 and 12, 13, there are interim orders operating in my favor. Kindly see this chart. The MGQ LPL is 64,452, whereas I have lifted 69,292 in that year. Let's see, getting that, man.
Yes, yes.
But if that is the position, my lord, and collector has permitted us, no demand can be there, my lord, and collector's permission is available. Annexed 4, my lord. Page 13 of my petition. So they have been acting in a hyper-technical manner. Monthly short lifting of MGQ, since I have already made it throughout the year, there should not be any demand against me. That's the short point is.
And there
is a judgment, my lord. Lakshmi Manti's case covers my point, my lord. Okay. The honorable division bench of this honorable court already held that. Kindly see.
so far as the impugned demand is concerned, that is in consonance with the rule prevailing during that particular period, excise policy of that particular period. So now he is saying that subsequently it is amended and yearly MGQ came into picture. So the demand was of the year 2013, and more so if all these things have to be taken into consideration, then your lordship may direct the excise commissioner to decide all these things and pass necessary orders. Because there are disputed, because we have filed counter affidavit, my lord.
Second, Mr. Mansi.
So, my lord, we have filed counter affidavits. There are disputed question of facts.
No disputed.
Excise commissioner.
Annexure 4 is there, my lord. Kindly see Annexure 4. Collector has permitted us, and we have lifted it. Where is the dispute?
But the counter says that we have made the demand.
No, that's
considering the prevailing rules. So if you say that even if that rules is provided,
that rule provides collector to grant permission. That's there. Accordingly, collector has granted us permission. Rule 6A, my lord, kindly see 2.
And this is a demand of district superintendent and collector. So you can approach the commissioner, the status quo.
Kindly see demand amount 30,000, 40,000. For this meager amount, again, we'll have to travel commissioner, again come back to your lordship, my lord, 30,000, 40,000 demand. And we have paid much beyond that by lifting. Kindly see Rule 6A, sub Rule 2 of prevalent rules. Kindly see that, man. 1 second. Let me show your lordship. Rule 6A of 1989 rules 2, sub Rule 2, Roman 1, provided that. Not old book, my lord, old rules.
I know.
It is old rules.
I'm giving it. আচ্ছা আমার আছে রেকর্ড লিখে রুলটা কাইন্ডলি সি দ্যাট
Yes.
and kindly see judgment para 11 minute that has been taken note of, and this honorable court has held that annual MGQ should be there. Kindly see, we are thus of the view para 11, and this is of 2005 minute. This judgment is of 2005. We are thus of the view that Rule 6.1 of Odisha Exclusive Rules 1989, the petitioner is not entitled to adjust quantities of foreign liquor or beer lifted by him in the previous months in the excess of MGQ certain so and subsequent month, and has to pay the duty of certain MGQ subsequent month, and hardship or inconvenience of the petitioner cannot be a plea waiving the MGQ. Communication dated so and so is this manner. Then, para 14. In any case, the licensee has been allowed to adjust certain MGQ of any subsequent month by excess drawal over and above MGQ of any previous month. This is a benefit given to the licensee contrary to the provisions of sub-rule 2 of so and so. Such an illegal benefit granted to licensee cannot be ground to court to direct such illegal benefit to be granted to the petitioner. Article 14 of the concern, any person equality contrary to so and so, Article 14. But the petitioner cannot be denied, para 15. But the petitioner cannot be denied the benefit of adjusting excess trial of subsequent months against the certain MGQ during the previous months, merely because he has not applied for such benefit during the term of the license. Kindly similar to para 15. Under sub-rule 2, the petitioner could be allowed such benefit by excise commissioner. There is also nothing in Rule 6A which prohibits the grant of such benefit to a licensee after the license period. Rather, sub-rule 5 of Rule 6A clearly states that licensee shall sell entire quantity of MGQ for the excise year before expiry of the term of the license. We therefore hold that petitioner will be entitled to adjust any certain MGQ of any previous months during 97, 98, 98, 99, 99, 2000 against excess trial over and above during the subsequent months during the aforesaid period of 3 stops. The excise commissioner will accordingly pass orders and areas.
There is no shortfall at all.
Yes,
We have no shortfall at all. We have lifted the entire.
that is disputed. That is what
How
I'm
can it be
saying. So
disputed?
far as the shortfall is concerned, even if the yearly MGQ is taken into account, whether you have completed it or not, that is why in that case the honorable court has directed the excise commissioner to take care of. Your lords, yes, in counter I have said that there is shortfall of MGQ in each and every month. So far as that, we have justified the demand.
What have you said to his annexure 5 in your counter?
No, he is saying that I have adjusted the entire
He has
MGQ.
lifted more, he says. He's lifted far more than the MGQ.
Yes.
These are all disputed questions. That is why in that reported case also, your lordship
One
will
thing, there's
find.
an annexure 5. Let's see what para of the writ petition is annexure 5.
Lordship is holding 13631.
Where is marked annexure 5? Annexure 4. Sorry. No, it's the chart, annexure 4 is it?
Annexure 4 is the collector's order. Permitted me to lift it. And I lift it.
Where is this chart?
Chart is in blood, flag C, annexure 5. Flag C.
That's it. And our annexure is annexure A by 3. In our counter affidavit.
But collector has permitted me to lift it. That is annexure 4, and I lift it.
No,
I
so
lifted
flag C was a 17441 IA.
blood 13631 of 2014 is the writ
That's the
petition.
petition, no. This flag C is enclosed with 174441.
IA number 17441.
So I don't think you have filed a reply to this IA, Mr. Mohan.
No, there is no reply. to
So
that.
that is where he's trying to show in flag C that he had actually lifted more than the MGQ.
Yes.
Much more than the MGQ.
That is why I suggest your lordship that these things have to be verified, and in the light of that decision, the commissioner will pass necessary orders.
All right. The petitioner claims that in almost.
Can it be relegated back to the collector? I'm sorry, my lord. Can it be relegated by collector? Because materials will be with collector.
No, collector,
collector-
commissioner, because collector is, there are so many assignment to the collector. Excise commissioner, you will get good and speedy order from commissioner. Don't go to collector.
Mr. Bharti is.
Don't go to collector. You go to commissioner. You will get speedy justice.
a demand notice dated 4 July 2014 issued by the Superintendent of Excise Bhadra. The petitioner. For realization of short drawn quantity of MGQ of IMFL and beer for the year 2011-12 and 2012-13 is under challenge in the present petition. Paragraph. While directing notice to issue in the present petition on 7th August 2014, this court stated the operation of the demand notice. Stop. Paragraph. Pursuant to the notice issue, replies have been filed by the opposite parties. Stay. Stop. Separately, the petitioner has filed IA number 17441 of 2022, enclosing inter alia a statement of lifting of MGQ by the petitioner from April 2012 to March 2013 as Annexure 5. Paragraph. The contention of the petitioner is that the said statement enclosed as Annexure 5 to IA number 17441 of 2022 would show that in every month from April 12 to March 13, petitioner has drawn much more than the MGQ quantity. We'll stop. On that basis, Mr. Ratha states that the demand was wholly unjustified as it was raised without referring to the above figures. We'll stop. He also places reliance on the decision in Lakshmi Narayan Mahanti versus the State of Orissa, 2005 99 CLT 389, which explained the scope of Rule 6 capital A of the Orissa Excise Exclusive Privilege bracket Foreign Liquor bracket Rules 1989. Paragraph. Having heard counsel of the parties, the court is of the view that the Commissioner of Excise, the Excise Commissioner should examine the figures now produced by the petitioner and pass a fresh reasoned order on whether the impugned demand notice issued to the petitioner on 4 July 2014 was justified in law. Paragraph. The matter will now be placed before the Excise Commissioner on, should we say, 1st March 2023, on which date the petitioner will appear along with a downloaded copy of this order at 11 a.m.
Yes.
Full stop. The Commissioner will examine the aforementioned judgment cited by the petitioner in light of Rule 6 capital A of the rules and Annexure 5 and pass a fresh reasoned order as regards the impugned demand notice dated 4 July 2014. Within a period of 3 months thereafter. The petition is disposed of. Till such time, no coercive steps shall be taken against the petition.
One just suggestion, my lord. Every month I have not lifted excess. By end of the year, I have lifted excess.
That we should show that by the end of the period,
yes,
the quantity lifted is much more than the MGQ. Right.
Great. The same orders will be there in item number 66 up to 66. But in 65 I have not filed in IA or a chart. That may not be.
64, 65, and 66.
You say in 65, 66, you say in view of the order passed today by this court in WP Civil 13632 of 2014, the present writ petitions are disposed of in the same terms with the same directions.
In item 65, I will file a fresh chart before the commissioner. That is not available for him.
That's all right. The petitioner is permitted to place
I am grateful.
the further charts, documents
yes,
for the Excise Commission.
That will do.
Right.
Item number 67.
67 not present.
Not pressed. Dismissed as not pressed.
Item 68.
Under item 68, there are four matters, my lord. WPC 22,536. Lord, this is regarding government land. And the last one is 12,792. That is government land.
So in
Out of
22536 of 2014 and 12792 of 2014, this order.
First one and the last one of that item
That's it.
68. But I have written also WPC number I have written.
All right.
That is government land, Lord.
All right.
Lordship's order is there.
The other
Lord,
two?
thereafter, WPC 9562, here, my lord, is demand notice is there. I'll approach the Commissioner Excise.
In petition civil 9562 of 2014, counsel the petitioner seeks leave to withdraw the present petition, with liberty to approach the excise commissioner in accordance with law against the impugned demand notice. Will stop if such an application is filed before the excise commissioner not later than 1st March 2023, accompanied by an application of continuation of delay, explaining the delay on account of pendency of the present petition. It will be taken into account by the excise commissioner. Full stop. The excise commissioner is requested to dispose of the petition after hearing the petitioner within a period of 3 months thereafter. Till such time, the interim order passed with this court on 12th August 2014 will continue. The same order in that next one.
The next one is the covered matter. Lordship's order is there. Some part, my lord, it was relief was granted. The other part is that this is the writ petition. My lord, I have given that.
All right.
I have corrected also.
All right.
Demand notice and date I have given.
All right. In 11305 this order.
This is my lord, the WPC 11,305.
Correct. All right.
Item number 69.
69, your lordship, permitted to withdraw. I'm on visa.
Just withdraw. All right. No instructions.
Obliged.
Item 70.
And please, my lord, in this case, counter has not been filed yet. This is the case, shifting of excise nearest to the petitioner liquors.
Period is all over, sir, now.
After the new excise policy, it is infructuous.
Yeah. In view of the subsequent development, the present petition has been rendered infructuous and is disposed of as such.
Item 71.
But 71, 72, 73, three matters are audit objections.
Audit objection.
Yes.
Same order.
71, 72, 73. Three matters, my lord, audit objection. Lord, and 74, that is, my lord, with regard to demand notice, your lordships have already dictated in WPC 9562 of 2014. Item 68, second item, sub-item.
Right. Same as 9568 of 2014.
Only date will be changed, demand notice
74.
and.
Yeah. The dates have to be changed. All right.
75, my lord, not pressed.
75 dismissed as not pressed.
76.
76, my lord, similar order may be passed. My lord, the State Pollution Control Board matter, they have not issued EC till yet. My pending application is there.
कौन देखा order पे?
All right. Same order.
77.
77 become infructuous.
Okay. Dismissed as infructuous.
Item 78.
78, Lord, is appeal challenges an order of the Honorable Single Judge where they had a recording of 1983 has been interfered with after 27 years by the Commissioner. The Honorable Single Judge notes.
Item 78, my lords. There's a copy of the writ appeal has not been served on us.
Notice had gone. Notice.
Copy will be served on counsel to the state.
I'll serve one of the.
Today itself. List on. (16th May).
Item 79.
None appears dismissed.
Item 80.
My lord, in item 80, I am appearing for the respondent. I need some more time to take instruction, my lord. It was admitted in the month of December. I need some more time to
At the request of Mr. Manthi appearing for the respondent. 11 July.
Not.
Pastor. Supplementary list passed over matter item number 4. Supplementary list item number 4.
My lord. My lord, may permit me to. My lord, in this matter, I am seeking for a direction to the Tahsildar Mahanga, that is the opposite party number 2, for demarcation of the government road and eviction of the unauthorized occupants on the said road, my lord.
We made them parties.
My lord, they have been pleaded as parties, my lord. Opposite party number 3, my lord.
All right. The
My lord,
petitioner's representation, bracket, annexure 7. You made it to the law minister.
my lord, let me just apprise my lord regarding the basic facts of the case, my lord.
No. See, the representation normally is addressed to the collector or Tahsildar. You've addressed it.
I have addressed it to everyone, my
All
lord.
right. You say the petitioner's representation, bracket, annexure 4, will be examined by the Tahsildar Mahanga, and after issuing notice to the petitioners as well as opposite parties, 5 and 6, is it? No, opposite parties.
4 and 5.
4 and 5, my lord.
No, 5 and 6, I think.
My lord, opposite party number 5 and 6 are the unauthorized occupants, my lord.
That's right. They have to be heard.
Opposite party number 5 is the unauthorized occupant, and opposite party number 4 is the IIC, and 6 is the Amina.
All right. Opposite party number 5 and giving them a hearing. The reasoned order shall be passed not later than 10th April 2023, and copy of the order shall be made available to the parties within a week thereafter.
My lord, I could not hear my lord regarding the operating portion of what my lord dictated right now.
You can read out what you think.
Representation be disposed. My lords, I'll apprise. I'll appraise.
My lord, here in fact, actually the demarcation had already been done. And when we applied for the certified copy, it was found that the Tahsildar, the RI had manipulated.
The problem is we don't have the luxury of repeating ourselves.
My lord,
you can replay this hearing. It's available on YouTube. Okay.
I'm sorry, my lord.
All right. The court clarifies it is not expressed in the matter. All right.
Item number 25. 25 to 40.
One person.
25. Supplementary list item 25.
Sorry, man. Sorry.
There were two matters, I think 30 and 32, is it?
30 and 31. Two matters there the respondents have appeared. In other matters, the respondent have not appeared for the first time this matter has been come. All the matters relating to that case of Sarath Parida have supplied the copy of your lordship's order.
Same order. Only the dates will change. It will go back for the single judge. Just show me the dates. In 30 and 31, he said despite service of notice on the respondent and appearance having been entered on their behalf earlier. Today none appears. Where's that order? The delay is condoned, you say, in both. No, this is only issue notice. All right. There is another judgment where we have fixed a date. Yeah. Since the impugned order was passed on the very first date, then we passed those orders.
I can supply it. It is
without the opportunity to the appellant to file a reply. It is hereby set aside and the matter is remanded to the single judge. And the matter that is writ petition civil 22316. And in both it's the same, is it? challenge is to the same writ petition.
No, one is
19637.
19637, another is 19636.
No, 22316. Or 636, all right. And the two writ petitions, that is 19636 and 19637 of 2019, are restored to the file of the learned single judge, where they will be listed on 1st March 2023. The petitioner will file its reply to the both writ petitions on or before 20th February 2023, and rejoinder thereto by the respondent writ petitioners will be filed before 1st March 2023. There will be no further time granted for the above purpose. The learned single judge is directed to, is requested to dispose of the petitions as expeditiously as possible, and preferably within a period of 6 months thereafter. During the pendency of the writ petition, status quo shall be maintained. But the writ appeals are disposed of in the above terms. This is 30 and 31. In the other matters, you say notice returnable 1st May. Not 1st May. The notice returnable 8th May 2023. In the meanwhile, the impugn order shall remain stable. Of the learned single judge shall remain stable in all other matters. Defects be removed in the meanwhile.
Myra.
That's right. Wherever there's IA, you say notice on the IA. Wherever there's, and you just say defects be removed in the meanwhile, the main writ appeal. Wherever there's an IA for dispensing with, all those IAs are allowed.
Up to item number 40. Item 41.
May please.
That violation is there.
There are two matters before your lordships. But before your lordships, I have given out some brief notes and dates.
Yes.
Before that, I'll take your lordships to show the scope of this case, my lord.
Yes.
But the petitioner before lordships is the Paradip Port Trust, the authority under the Major Port Trust Act. Now they are called the under Major Port Authority Act. Then the respondent was Paradip Phosphates Limited. The Paradip Phosphates Limited, there is a relevance of it, was an erstwhile public sector. Now it has been privatized. But the dispute arose, dispute is relating to scale of rates of a captive port, which is being operated by PPL under the Paradip Port. But under the Paradip Port, there are different captive ports given to the different port users. And particularly the fertilizers. It's a fertilizer plant, and there's another fertilizer plant, IFCO. There's a relevance because there's something called parity, IFCO and PPL. Now, beloved, when there are three periods. The first period is from 1985. There's an agreement with the PPL, which was a public sector, stating, Lord, the relevance of it, which has been highlighted by everybody, including the authorities, is that we had an agreement with them. We said that the scale of rates and the fixed rates shall be changed by mutual consent. There's a provision that it can be changed by mutual consent, which is being harped upon by them. But the statute then provided, I've given the statutes in my small notes, my lord, whether the statute existed then. The statute then provided that the scale of rates shall be fixed by, your lordship sees the statute, that your lordship get it at page 7 of the notes, statute that existed in 1993. But we had an agreement in 85. First time in 1993, following the statutory procedure, we imposed and changed the scale of rates, not by mutual consent, by following. That is, your lordship stated at page 7 of the notes. Lord, the 48, scale of rates, every board shall, from time to time, frame a scale of rates at which in a statement of the conditions, etc., shall perform by a body. 48 gives the power, Lord, and the 48 can be exercised by with a prior sanction of the central government, that your lordships get it at 52. Every scale of rates and every statement of conditions framed by a board under the foregoing provisions of this chapter shall be submitted by central government for sanction and shall effect when the sanction is published by the board. But we followed this procedure, took the approval of the central government and notified the change of scale of rates. But this was in 1993. In 2000, that is 7 years after that, the PPL challenged this change in a suit. Because these facts are there's little jugglery of facts. I have to take your lordships to different facts. They filed a suit in 2000. That is 7 years after. A point to be noted here, whether it is clearly barred by limitation because 7 years after it they challenged in a suit. Now this suit was decided that in the course of the suit, that since they are both government bodies, as your lordship knows, then the law prevailing was of ONGC case, that the inter-governmental disputes shall go to a governmental machinery, a joint secretary, and an appeal by the appellate secretary law. They decided that this shall go to the authority. Instead of a suit, it shall go to the authority. Now, the joint secretary at the government of India who decided this, decided against us, depending upon the clause called mutual consent. Now, the appellate authority also decided against us. That is the challenge before a lordships. Before a lordships, the first case. The second case is slightly relating to the different aspects. So let me consider the first case, Lord. My challenge, my submission to your lordships is twofold. A, that first of all, the proceedings of 1993 notification of the Paradip Port, taking the approval of central government, and cannot be challenged in 2000, that is 7 years after. 7 years is the limitations. It cannot be that it's stayed, it's limitation barred. Second, my lord, notwithstanding any agreement, if there is a statutory provision, an agreement cannot overcome a statutory provision. If statute provides...
No, the statute predated the agreement or was
statute predated the agreement.
So if the parties intended that the statute should apply,
Lord, what I humbly
should have incorporated a clause in the contract saying
there is a contract in the clause, my lord, which says that there is also a contract in the clause which says that every rules and regulations of Paradip Port shall be binding on both sides. That's also there.
No, statute, as far as the statute. Let's see the clause in the contract now.
Yes, kindly see, Lord. Contract if lordship sees, Lord. Lordships kindly turn to page 111.
In the first writ petition.
In the first, Lord. One other thing, your lordships kindly keep in mind, 85 agreement, 93 the amendment, 2000 till 2021 or 93 also, there's no change till now because of while a similar, I've given a comparative chart.
So this is what per square foot of the area you charge a tariff, or what do you do?
It is what is that this is called
storage capacity.
No, this is according to the tonnage.
Tonnage.
We give the provisions, we give the berth. They use their own berth according to the tonnage of use. There's a one fixed berth charge, 1 tonnage. And your lordships, kindly see the agreement. Before that, my lord, your lordship sees, my lord, I've given what you wanted is that IFCO and IFCO has been, IFCO is another fertilizer plant. Your lordship sees in page 16, my lord, we've given a comparative chart. In fact, from 93 till 2021 also, there's no change.
What is this arbitration award all about?
That arbitration award is not under the Arbitration Act, Lord. That is the same, the intergovernmental dispute known is called an arbitration. They're known as arbitration and they've been more clarified.
That so that went against you in the award was against you, the appeal also went against
you. Yes, Lord. Yes, Lord. Both are against me. But the fact remains, my lord, that they have gone under agreement. Not my submission to your lordship is that notwithstanding the agreement. And my lord, your lordship also kindly take into consideration. When the agreement was made, it was made with the public sector. Now it has also ceased to be a public sector. It's a private sector. As your lordship knows, in between government, there is a different ways of making an agreement between the government
No,
and the
but then
private.
you should revoke that agreement and ask them to enter into a fresh agreement.
No, Lord, what I humbly submit to your lordships, notwithstanding that, the question before your lordships would be that can an agreement between the parties.
But why didn't you cancel the agreement?
Because there is also that they did not, whatever the wisdom.
So that must have been the,
Yes,
the other party goes by whatever the other clauses in the agreement.
No, he said that it is not that it cannot be changed. It's changed by mutual agreement. It also provides. Or also sees that agreement provision. No, that is at.
Why is it called a share purchase agreement?
No.
Annexure 4, it reads as share purchase.
No, I am referring to page 111.
That's right. 111 is part of a document which begins at 101. And that document is titled Share Purchase Agreement.
101, your lordship is referring?
Yes. Writ Petition Civil 732 of 2012.
Writ Petition 11. No, I'm referring to WPC 11 of 2010.
Oh.
That's the first case. That is the first case.
I see. All right.
I'm referring to pages of that case.
Okay. All right.
Yes. Lord, kindly turn to 111.
Yes.
111, Annexure 6, page 111. Lordship, para 1. That the state captive bird, para 1, Lord, shall be exclusively provided for use of Paradip Phosphates Limited and subject to payment of rates mentioned in the schedule. The rates are mentioned in the schedule. Then the agreement will become payable. The rates now charged can be suitably enhanced at such intervals as would be mutually agreed upon by the parties from time to time. This is the clause
which is coming your way.
Is coming my way.
Right.
19, your lordship says, 19, 114, page 114, 19, clause that the Paradip Phosphates Limited shall be subjected to the application of relevant laws, rules, and regulations of Paradip Port Trust. Not, may I humbly submit to your lordships, when a statutory power, notwithstanding an agreement which has come later or before, can never be curtailed by an agreement. That would be my submission to your lordships. A statutory power of a statutory authority can never be curtailed even by an agreement, even if the agreement is anterior or post. That's my submission to your lordships, because that's being the intention of the statute, a power, because agreements are made by authorities, but the statute is made by the.
No, if it was like signing on the dotted line or something, this is not that kind of an agreement.
No, one is not.
No. So there are many aspects covered by a statute, but some of those aspects, the parties knowingly enter into agreement, agreeing to.
And the situation has also changed to the extent, my lord, that it was not no more a public sector. It is because the lordship says.
Because the Act came in 1963 itself.
Act is old, Lord. Act is old.
I'm saying the Act, which had these sections which gave you the procedure for revising a tariff, was already there when the agreement was entered into.
Yes,
despite which you voluntarily agreed to a clause which said by mutual agreement you will fix the tariff.
What I humbly submit to your lordship, subject to your lordship's consideration, is that the agreement cannot, to that extent, Lord, if not, I am supported by some views of the Supreme Court, if your lordship kindly see, Lord.
So what is the difference we are talking of? What was fixed under the agreement and what is now fixed by you under the statute?
Yes, Lord, kindly, that your lordship. In fact, from the point of equity also, your lordship see that how equitable we are. Just kindly see, Lord, even otherwise. Lord, your lordship, kindly see the last part. the last in the notes, my lord, the comparison between
Correct.
births, my lord, is given. Your lordship sees, this is 85. If you also get that PPL and FCO in that page, there's a 16.
Right.
Lord, there's a tonnage and there's fixed welfare charges. Birth hire charges is 30 lakhs per month. Then your lordship says wharfage, means that as per the tonnage, up to 3 lakhs 70 rupees, up 3 to 6 lakhs, it goes down, my lord. Like income tax, my lord, goes up, it goes down with more and more of tonnage. Then your lordship says in 1993, what we did, my lord, is a change is 5 lakhs 65, 5 lakhs to 10 lakhs 50, and 10 lakhs and above 25. That means this wharfage rates, the birth hire charges remaining constant, this wharfage rate was altered to certain extent. In 93, that is after 8 years. This 93 is 8 years is continuing per same lord. 65, 50, 25. Then your lordship sees in 1999, the other came. The other similar fertilizer plant came, that is IFCO, and which has also.
So this arbitration happened by your own board of trustees?
No. Arbitration, that's not, to start with, it's not arbitration under the Arbitration Act. It is that arbitration nomenclature is called arbitration. It is itself says that the Act of 1996 is not applicable. It is that intergovernmental machinery.
No, but come to clause 20 of the agreement.
Yes, Lord. Clause 20 of the agreement, Lord, is referring to
page 114.
Yes. 104.
No, 114.
114.
Clause 20.
In case of dispute arising in relation to this agreement for interpretation terms and clause shall be referred to arbitration or board of trustees. That any case has not been referred to board of trustees, not board of trustees decided, nor there is an arbitration. What was referred to was an intergovernmental dispute as per the, as well as ONGC. I have given the clauses of the ONGC case to the government joint secretary. Now, no arbitration on my side, not my arbitration, not 20. Clause 20 was not invoked. It was from the suit, because no suit can lie that in the law was the ONGC case. It will go to intergovernmental dispute. It's an intergovernmental dispute. It's an administrative machinery, an appellate machinery of administrative nature of the appeal court. But because both are government, they are still bound. But what has happened peculiarly is that in 2002, it was privatized. Now one is a government, the other is not a government.
No. So the decision of that machinery was delivered when?
The decision of the machinery was delivered post 2002, Lord, after it became private. And
how can it deliver the decision after it's become private?
Well, that was one of our objection to that it cannot deliver after the.
Correct.
One of our objections also.
Correct.
But I'm Lord, why I'm not. There is a reason why I'm not insisting on that, because the matter in a different context had gone to Supreme Court. And the Supreme Court said that the parties shall be abide by the decision of the High Court in this matter. So that, but the fact remains that it is not a governmental machinery. So your lordships can refer to an arbitration of.
No. See, I think just come to internal page 3 of your note.
Sir.
The joint secretary held that rates cannot be in perpetuity and needs to be reconsidered, and directed the rates may be reviewed by the tariff authority for major ports with effect from 1499.
Yes.
So we're now looking at a period up to 1499.
We are looking at a period of both from 93 to 99, which is covered by the judgment of that court. Then they referred it to tariff authority or major port trust, because then the law had changed. Law had been changed that the rates shall be fixed by the tariff authority in 99. That's the reason it changed it. Tariff authority or major port trust were not decided from 99 and till that cover till now. It goes on. Is that they fix the same rates, and that's the subject matter challenge the other rate. That the subject matter challenge the other rate.
Learned friend doesn't mind, just 2 lines. Well, there are dispute, as the lordship rightly said, is not. The first period is 3885 to 1993. No dispute.
No dispute.
3rd of August 1983 to 1993, no dispute.
Right.
1993 to 1999 was the disputed period before the authorities.
Correct.
Now, I become a private sector in 2002. 2002. So the dispute period, PPL was a public sector. Now, 2000, after 1991 and after 1999, TAMP became the authority of the port trust to decide the tariff.
Right.
So TAMP also held in our favor in a way.
Right.
So therefore, the second petition is challenging essentially the TAMP's order.
Right.
TAMP being the authority making order under the major port trust.
Right.
That's the point.
Yes, my lord. That's exactly my case also, my lord. So, if your lordship sees straight away from the first of all, from the legal point of view, my case stands on the footing that the act shall prevail, notwithstanding any agreement. That's for your lordship's consideration. Lord, I received a judgment of that Patiala, if your lordship sees, Lord. It agreed. Your lordship says para 32. The provision of section 19(2) make an agreement between the employer and employee binding. It also lays down the period during which shall be binding. It also provides the manner in which the agreement can be terminated inter partes. It does not follow from this provision that a competent legislature cannot legislate in matters which form part of the agreement. Nor does section 19 have the effect of validating any informity in the agreement. If the agreement is contrary to any law, or if the agreement cannot be implemented without violating any provision of law, then the agreement cannot be enforced at all. There is nothing in subsection to suggest that even such an agreement continue to be binding upon the employers and the employee and enforceable against.
So it's a very different kind of clause.
Yes.
So obviously 19(2) talks of the agreement. It's a very different kind of a clause.
The 19(2) of the Industrial Dispute Act talks of an agreement. Now, I know that. What I humbly submit to your
So then to say that you should still give effect to the agreement if it is contrary to section 19 would be absurd. That's why they say.
Yeah. So
whereas here it's a very different thing.
But here, Lord, my submission to your lordships would be that once there is an A, that, I mean, taking the entire case is this, I can't go beyond it. That once there was an agreement between me and the public sector, and then was the public sector, it stated that the agreement shall be by mutual consent or mutual
agreement.
Mutual agreement. It also provided that all rules and regulations applicable to the port are applicable to them. All the rules and regulations as it existed on the date of making of the agreement and thereafter is the power of changing is given, because now the central government doesn't feature here in the agreement.
No, but you'll have to harmonize this clause 19 with the earlier clause which says it should be by mutual agreement.
The mutual agreement is not a provision of any statute.
May not.
No.
So, but it's certainly part of the agreement.
It's part of the agreement. Yes. That you know. So
suppose, for instance, this tariff fixing provision, let's read that again. Which you had given this compilation.
In the compilation, the law provisions? Yes. Yes.
This section 48.
Yes, Lord.
Suppose section 48 had said, notwithstanding any agreement entered into by the port.
Yes, it doesn't provide for, but it also doesn't provide that my humble submission to your lordships would be that a law does not provide that notwithstanding any agreement. The law also does not provide that an agreement can overcome this. An agreement between the parties, like, I mean, it's a general principle to be kept in your lordship's mind, that supposing there is a law provides a particular manner of fixation of tax or fixation, can an agreement take away different from notwithstanding the law?
Why not?
Depends on
that's the whole purpose of an agreement, isn't it?
Yes, that would be, and number two, and whether the substance of the agreement survives after it is a public sector, ceases to be a public sector.
That also we don't know. See, unless you choose to say that since there's a private entity, which is now PPL is a private entity, you revoke the earlier agreement, then that's a different issue altogether. If you do not revoke, the entity continues as such. It's just that the shareholding of the entity has changed.
No, the very fact that as your lordships had fallen from your lordships, that the dispute went to them because it was a public sector, and the dispute ceased to be, and in the meantime, it ceased to be a public sector. while the dispute was pending itself, ceased to be a public sector. So the dispute resolving body itself.
That's right.
And we had raised it.
No, but I think there he's got a point. The dispute pertained to a period during which it continued as a public sector.
First part.
That's right. So they could still have decided it up to 1999.
Up to that became the public sector.
Up to 2002.
2002 they became.
But the dispute period itself was only till 99. So anyway, it would have covered.
2000 from 99. No, the second period went to TAMP, which is subject matter.
So that
challenge.
doesn't matter now.
That has been challenged before Lordship separate, that we have not been given an opportunity. That is there for another case. Another case. So,
So the second one we can still examine. First, I don't see why we should interfere. You went in appeal also.
Appeal.
All these are government bodies. Joint secretary followed by additional secretary
Yes.
law.
But your Lordship is from the, first of all, if your Lordships are possibly convinced from the equitable point of view, then your Lordships may consider.
That's right. Even the comparative rates.
Yes.
It's quite marginally more for Oswal and all.
No. What I humbly submit to your Lordships is, Lord, kindly see, Lord. Kindly just see.
Because we are only to see the 99 rates, correct?
No, your Lordship kindly go through it. Right, like 93, my Lord, when you made it 65, 50, 25. Then in 99, the other thing came, my Lord, the birth height charges increased to 37 and this continued.
No, only 99 it changed. Even for Oswal and all.
99, they came forward. They were not there. They were not there prior to 99.
So we have no comparisons. Therefore, no. I think you leave the up to 99 period.
But what I humbly submit to your Lordships, kindly see, Lord. Oswal, your Lordship.
Pre-TAMP thing, there's no case that you have.
Your Lordships?
The pre-TAMP.
My humble submission to Lordship that the agreement doesn't, that your Lordships for consideration.
Yes.
I mean, I have nothing more to say than except that the agreement cannot overcome the statute.
Right.
So, and that is done by central government with an approval. And after 7 years, the challenge is after 7 years, my Lord. Lordship will never, otherwise also entertain a matter of challenge after 7 years. 7 years. This notification was made in 93 and the proceedings started in 2000. 7 years.
I think it's only when then the earlier PPA,
yes.
Public sector.
No, even public sector started in 2000 after 7 years. The notification of 93. Lordships normally would not entertain a matter.
You mean the statutory notification? By exercising
statutory. For which we claimed and they paid the amount. They have been paying on the rate of 93, which is from 93 till 2022. There's some changes now, I'm not sure. 93 to 2002, they have same rate. Not that there is no increase, while Oswal continues to be increased.
So what does that award or whatever decision say on the question of latches or delay? Did you raise it?
Before the authority? Yes, my Lord. I have to slightly recheck the bulky facts, so if you not give me.
No, the copy of the decision should be there, right?
Yes.
Appeal order is here.
Yes.
I think the original order is 17th March 2009.
2000, yes, this.
That was not a question raised before the arbitrament.
That's what I thought.
Your Lordship sees page 36, the issues have been called out.
And it wasn't raised in appeal either. That's it. There's no issue framed on limitation. No issue at all. And let's see the appeal that you have filed.
The order is there, my Lord. Appeal order. Again.
But if your Lordships kindly turn to page 139, The contentions have been noted, page 139.
Yeah, my lord, there's a point there, my lord, if your lord, this is 141. 141, my lord.
The ground of bar of limitation.
Yes.
Is misconceived.
That's what he says. That the court says. I mean, the authority says. The enhanced rates towards the unpaid under paid not duress. The question of enhancement not finalized. Parties continue to the bind and does not perish. The government's what they say that it doesn't perish at 142 with the agreement government's part of disinvestment in liquid. But if a lordship consider from the, I mean, my humble submission to lordship.
So he says cause of action arose in 2000 when the demand for interest on the alleged delayed payments was made, along with threat of stoppage of services.
When we asked for interest, but the main action was that would make the interest. Interest may not be.
Anyway, I think on the first writ petition, we may not be inclined to interfere. So let's look into the TAMP thing now.
Lord, in a TAMP, Lord, I have taken a major point is that not given a proper opportunity to place the facts.
(241) is the decision. Page 241.
Yes, in the second.
29/11/2010.
Yes, I'm just checking.
It's a very detailed exercise of them writing to you, asking for comments and clarifications. It's all back and forth. There's a lot of correspondence. Now come to para 8, page 256. Para 8, page 256. A joint hearing was held on 9th December 2009. PPT made a PowerPoint presentation and both parties made their submissions.
No, ruler lordships, kindly see, which I've quoted in page 18 and give the paragraph 5 of the paragraph 5 of the order. 5. Paragraph 5, no? But this I've quoted from page 18. I'm just finding out where it is, Lord. If Lordship sees page 18 of my that brief, I'm just finding out where it in the order. Page 18 of the brief, if Lordship sees. The final proposal, what I am finding out what is the part of the order because it's quoted here. The final proposal that takes a file by the PPT for the authorities, I think bound, I think that's also calculated there and continues to be here. We passed on the position ML the meeting held. Noted here that order that etc. passed to authority disposing the earlier proposal carry both the should file its proposal concern PPL. Since both the parties have undergone the process of mutual consultation between them and the manuals of meeting reflect the views of both the parties, setting up a personal hearing in this case is not considered necessary.
No, but that's not what it reads. Just come to the page I was referring you to.
Sir.
I think it was 256. Just see page 256.
Sure.
Para 8.
Para 8, yes. The gist of the hearing. What the yes.
Just read that whole thing. It's only 4 lines.
Yes, madam. The para 8, a joint hearing. This case was on 9 December. The PPT made a PowerPoint presentation. The gist of the joint hearing here as under. We have considered the figures. The court has created different infrastructure. People are not a lot of information. The difference between people in many areas, the reference of time, the original contract do not break up the rate specified. We agree that time PPL should adjudicate upon tariff payable from we are unable to furnish the cost breakup.
So there was a joint here. In fact, there's no para 5. Just come to earlier page 244.
Yes, ma'am.
There's only a para 5.1 and which reads very differently. So I don't know where you're quoting from in that page 18.
Once I quoted, it must be there, but I am not there. Yes.
No, I don't think anything that like that exists in this decision. In fact, there were several joint hearings. Even para 3 talks of a joint hearing.
Not, I mean, that could be the position, Lord, but however, Lord, I will only honestly request your Lordships to kindly see the equitable part of it. And from 93 till 2003, while one other fertilizer is going more and more and more, the other is static. Static from 1990, that means it will be static from 85 till date.
No. Does anything prevent you from revising using the TAMP? Periodically, you go with TMP and ask for revision of tariff.
No, TAMP, again, whether the TAMP as in substituted by another statutory provisions.
Whatever. I'm saying, is there a bar to your filing fresh applications?
This is relating to the past. Because now...
No, I'm looking at electricity tariffs and those kind of tariffs. When you have electricity tariffs,
yes,
it does not mean that, like, let's say that you got a decision from the tariff authority on 1st of January 2021. It means for all times thereafter, you can never go before the tariff authority.
No, it can. Revised.
So this doesn't mean that this is the end of the road for you.
But what I humbly submit, Lordship, take this fact into consideration, whether it would be fair to me and fair to the other fertilizer company that one becomes static, the other becomes changes. Then that your Lordship says, and I am also
you're only a port trust.
Yes.
Why are you bothered about one fertilizer company or the other?
No. He is also a captive bird. He is also a captive bird. And I depend on their income to increase my port. That is our Lord, you will also see, my Lord. I have given the comparative chart, my Lord. IFCO and PPL. It's all, one is static. Static from 1985 now. Now, what is that? That shall be periodically changed.
No. After TAMP has come in and done such an elaborate exercise. It has compared the IFCO rates as well.
So
it's a very, very elaborate exercise. What TAMP has undertaken. And it's a specialized body. See, one cannot substitute the views of the TAMP. We are not an appellate authority. It's a writ petition.
Yes.
So writ jurisdiction basically look at
No,
procedure.
opportunity.
Procedure, nothing else. This authority, the TAMP, is a single member authority or a?
It's a body.
Multi-member.
It's a body.
Because the signature is of the chairperson.
It's a body.
They were heard in the matter. And TAMP is a body, my lords, it's a statutory body with a statutory function. And your lordships have decided what fell from your lordships. What is the scope of judicial review? In 2019, 3 SCC 352, this is Reliance Infrastructure versus State of Maharashtra. I'll just hand over that judgment. Lord, both the interim order and the final order, series of hearings and participation, filing of documents, etc. Lordship may see page 376, paragraph 38. My lords have it, my lords?
Yes.
MERC is an expert body which is entrusted with the duty and function to frame regulations, including the terms and conditions for determination of tariff. The court, while exercising its power of judicial review, can step in only where a case of manifest unreasonableness or arbitrariness is made out. Similarly, where the delegate of the legislature has failed to follow a statutory procedure or taken into account factors which is mandated by statute to consider, or has founded its determination on tariffs on extraneous considerations, the court, in exercise of its power of judicial review, will ensure that the statute is not breached. This is not the case here, Mills. However, it is no part and function of the court to substitute its own determination for the determination which has been made by an expert body after due consideration of material circumstances. Therefore, the scope is very narrow. Now, let me tell you, Lordship, what is this private-public issue? Now, the dispute was from 93 to 99. In 99, it was the public sector. So it was not as if the private sector was there during that period. And post 99, we are governed by the TAMP regulation. So therefore, a statutory body has fixed the tariff. And TAMP also did not find any fault in the previous arrangement. Now, why this arrangement was made is, Your Lordship may kindly see, Mills. Your Lordships saw at page 111 was the agreement where, my lords, it said the rates now charged. Would Your Lordship see kindly page 111?
Yeah, can be suitably enhanced.
Can be suitably enhanced at such intervals as would be mutually agreed upon by the parties from time to time. My lord, what had happened at that time, this company was a public sector organization. And if Your Lordships kindly sees, my lords, page 22. Okay. Writ petition, right? My lord, kindly see page 22, annexure 1. My lord, why this clause were there? Your Lordships will get some light of this, my lords, at page 23. My lord said page 23. My lord, this is a part of the arbitral award.
Right.
What it says is, if Your Lordships kindly see, my lord, the last 4-5 lines, the Honorable President of India was also accorded separate approval for construction of the captive berth at an estimated cost of 15.5 crores. So therefore, this company invested 15.5 crores to build that berth, from which it was going to carry out its operations. So therefore, there was a clause there that now, since you have invested in this project, we will mutually decide from time to time what will be the enhancement. And from the time this has become a private sector, they are followed by TAMP and whatever is the regular mechanism under the statute. So in my humble submission, my lords, this clause was well founded, upheld by the appellate authority, who is the Government of India officer, upheld by the appellate authority, who is also Government of India. And at a time when this was, the award may have come later, but the point in dispute was that. And my lords, on delay, there is no delay because the arbitration agreement itself, your lordship saw there was the original arbitration agreement. The committee of, if your lordship sees, my lords.
No, you filed a suit only in 2000.
Filed a suit because they were not enforcing it all the time, discussions were going on. Because the discussions were going on, I filed a suit. And then they called me and said that now you enter into a COD, said you have an arbitration. If your lordships kindly turns to my lords, page 28.
Yes.
My lord, I'm sorry, my lord. Would your lordships kindly see, my lords, page 27. The claimant company, however, went, my lords have it.
Yes.
The claimant company went on protesting against such high-ended action of the respondents, but had to make payments under duress. Needless to say, the efforts were on the part of the claimant company, and ultimately both the Ministries of Fertilizer and Ministry of Surface Transport were involved for settling the issues forever, as per the contract stipulation. At no point of time, neither the respondent nor the ministry denied to review and settle the issues mutually. However, under the guise of assurance, the respondents tried to create enormous pressure on the claimant company to accept the scale of rates unilaterally fixed by PPT so and so. The claimant company were put to unnecessary risk so and so. That in due course of time, the respondents went one step ahead, imposing interest on delayed payments on fixed charges, which has not been envisaged anywhere under the contract dated so and so. The claimant company promptly protested against such illegal design of so and so a waiver of interest. However, ultimately, the traffic manager Paradip Port handed over the decision of the respondents on 31st of May 2000 to the managing director of the claimant company, wherein the claimant company were directed to deposit up-to-date interest on all delayed payments. Reasonings given were by the respondent, clause 19 of the agreement dated so and so, rate with so and so, compulsory rate of claimants company to pay interest on full delayed payment charges. It was further made clear that if any outstanding interest so and so. Needless to say, the claimants and the respondents were being parties under bilateral agreements are to act within the four corners of the agreement. It is respectfully submitted to the higher so and so. Your lordship may see the last paragraph that the cause of action was continuous in nature, for which no sincere effort has yet been made by the respondent, thereby compelling the claimants to so and so. However, cause of action arise finally. My lordship have last three lines, my lord. Finally, on 31st of May 2000, when final efforts were made by the respondents for so and so. So therefore, by that time, both were public sector undertakings. The two ministries jointly decided that the matter will be now referred to arbitration. My lord, they did not oppose. Ministry of Surface Transport would have said that, look, fertilizer, 6 years old, we are not going to arbitration. They didn't say that.
All right. On the second writ petition, TAMP.
My lord, TAMP, as your lordship knows, my lord, they are saying the whole argument was that there was violation of principles of natural justice. Your lordship saw paragraphs after paragraphs, both in the interim order and final order. They have been heard and their representations have been considered. And it is not alleged that the TAMP, there's no allegation of unreasonableness, arbitrariness, malafide, etc. My lord. So the second judgment squarely covers that case.
All right. Anything else?
Your lordship's consideration, Lord.
All right. So we'll come back after lunch and dictate it.
Deeply obliged.
All right.
So kindly recollect, I had pointed out a paragraph extracted, which I myself could not locate, and your lordships thought that not there. Actually, what you are being placed was not a part of that order; it's a part of the proceeding. In the order, it is there. Kindly turn to me, Lord, page 271. Page 271 of the second brief. That's the order. Order, it is there. Page 271 in WPC 732 of 2012. Kindly turn to page 273. Your Lordship got it?
This is a TAMP order.
In the TAMP order, if your Lordship kindly recollect, I had placed a factor that extract of the paragraph that no personal hearing is required because then your Lordships couldn't, I could not locate. Your Lordship thought that I have not. Kindly turn to 273. 273.
What is this order? What was I was showing you some other order?
No. What was being seen by your Lordships is not an order. It is the proceedings prior to the order. What is being shown by me to your Lordships now is the final order. In the final order starts from 271. Final order. If your Lordship sees 271, the final order starts. 270, it says in exercise of power. This is the
But how can one ignore what I pointed out?
What I am humbly submitting to your Lordship that may I just tell your Lordship where I stand corrected. I had placed before your Lordship that the TAMP in the final order has observed no personal hearing is required. Then your Lordship and given an extract in the read petition. I could not locate that in the order.
No, but this is not consistent with what TAMP itself has recorded in the proceedings.
The proceedings have been recorded, madam. Before that, if your Lordship says that no personal hearing, kindly see that part first, Lord, at 273, para 5. That para 5, if your Lordship may I just.
Sir, I have read this para 5 very carefully. I want you to now, after reading this para 5, kindly read what I drew your attention to.
Yes, what your Lordship got my attention is there, my Lord, in the proceedings.
So how can it be that in the proceedings you were given a lot of hearing, and in the final order it says no hearing?
No hearing is required for the final hearing.
Not that you were not heard. That's the whole point.
What I am humbly submitting.
You were trying to submit as you were never heard.
No. What I am trying to say the facts. I will not go beyond the facts.
No. Because your submission was
my submission was no personal. My Lord, there's a difference between heard and personal hearing. My Lord, I was given to ask to submit records. PPL was asked to submit records.
No. You were asked. In fact, if you want me to draw your attention, I will do it.
No, it is there, my Lord, that both sides
profusely, sir. You were asked to repeatedly give submissions, comments, everything.
Yes,
repeatedly. Not one hearing or two hearings. Several hearings.
My Lord, may I just clarify this aspect only. Nothing beyond, nothing more. That while the proceedings were continuing, it was asked me to submit profusely. They were asked to submit. I was asked to submit. They were asked to submit. But what was said, what is not given is a personal hearing on the finality of the matter. That is what has been recorded in para 5. That's what I'm brought to your Lordship notice. Kindly see para 5, my Lord.
Sir, para 5 I've seen now 4 times. Now I want you to see, since you've asked me to see it 4 times. No. You asked me to see it 4 times. You see this. 256 and then one more time.
May I stand?
Please come to page 256.
Yes, my Lord. Yes, my Lord.
Now you read that.
256.
Para 8.
Yes, my Lord. That your Lordship said I had placed before Lordship para 8.
No, I placed it before you, sir. You never say before me. Let's be clear on these facts at least. Let's not change these facts.
No. There is no. I don't want to.
No. We have to be clear. We have to be clear on what's happening.
A joint hearing was held. The PPT made a PowerPoint presentation. The Paradip Port and the gist of the hearing is held of 2009. No dispute on that. I'm not disputing that, my Lord.
Just come to para 6 now.
Para 5 of the...
No, para 6, page 245.
245, Lord. Yes, 245. Lord, with great respect, Lord, I never tried to...
No, we are going to dictate the order. See, the point is...
No, what
we are very
No, what?
We are very aware
I just
that we are very aware that judges make mistakes.
No, I am just
I
wanted
we
to.
are very aware that judges get it wrong. Senior counsel always get it right.
I am not.
Senior counsel always get it right. Judges always get it wrong invariably.
No.
So we have to be clear. No, we have to be clear because we're going to dictate an order.
Yes,
You should not tell your client, listen, the judge got it all completely wrong.
I am not.
The judge is talking through his hat.
No.
We don't want that.
Para 245, your lordship says? Yes, page 245. Yes, ma'am.
Para 6.
Para 6, my lord, PPL by letter has offered the comments on PPT's proposal. The said comments are forwarded to PPT for remarks. The comments of PPL remarks are offered.
Now come to para 3, page 243.
243, sir. Para 3, my lord. A joint hearing on the post proposal dated September 2005 was held on 4th June 2007.
So one more hearing.
Hearings are there. No, I am not.
Right. No, we should not get it wrong, sir. You are trying to correct us, saying you are wrong, I am right.
No, my lord.
So we are just trying to set that right.
I just put it this way. I wanted to tell your lordship that kindly, if your lordship bears me, what I wanted to say, I had quoted para 5 in my petition. Your lordships had observed that para 5 may have been wrongly quoted. What I am saying that I am not.
No, I didn't say wrongly quoted. I said we are not able to find it.
Yes, that not able to find out. That I have only placed your lordship that it is there. That is all, my lord. My purpose. I mean, there was course of proceedings, there was hearing, and thereafter, no final hearing, no personal hearing is required. That's what I said, and that's what I placed before lordships. Nothing more than that.
All right.
Grateful, sir.
There are 2 writ petitions filed. These are 2 writ petitions filed by the Parabati Port Trust. By the Board of Trustees, through its Board of Trustees, Parabati Port Trust bracket PPT, through its Board of Trustees. Full stop. The first writ petition, bracket civil, 11 of 2010, challenges an order dated
Assist your lordship.
17th March 2000. I'm sorry.
2002. Assist your lordship, my lord. First challenge was to the order dated of Joint Secretary dated 27/12/2000.
Order dated 27th December 2002.
Of the
passed by the Joint Secretary
as confirmed by the appellate authority.
Yeah. An arbitrator. The Department of Public Enterprises. Disposing of the claims and counterclaims. The disposing of the claims of the opposite party, Paradip Phosphates Limited, bracket PPL, and the counterclaims of PPT. Full stop. Also challenged is the order dated 19th October 2009, passed by the Additional Secretary and Appellate Authority, Department of Legal Affairs, Ministry of Law and Justice, dismissing the appeal filed by the PPT against the aforementioned order dated 27th December 2002 of the Joint Secretary. On 24th October 2010, an interim order. At 24th February 2010, while setting down the writ petition for a final hearing, an interim order was passed that the single court's award, unquote, dated 27th December 2002 and the appellate order dated 19th October 2009, open petition shall not be given effect to without the leave of this court. Full stop, unquote. By a subsequent order dated 2nd April 2010, this court declined to vary or modify the said order, but noted that what happened to those execution proceedings and SLP was filed and all that? That's all over.
The execution cases were filed on the ground that this is an arbitration award.
Award, correct.
Then their matter had gone to SLP. And the SLP the order is there before Lordship in the second brief. And WPC 732 of 2012.
All right.
475. Page 475. And what the lordships have said, minutes, that it will be disposed of expeditiously in case the lordship may see 480,
right,
the operative part.
Right.
It is clarified in case the award is upheld, the High Court shall ensure it is executed without any delay.
All right. All right. The court noted in the said order that arising from the execution proceedings filed by PPL for enforcement of the award, SLP Civil 14811 of 2009 was pending in the Supreme Court of India. It may be noted here that the said SLPs were subsequently disposed of by an order dated 12th January 2016, declining to interfere with the orders of this court and relegated the parties to urge all the pleas in the present writ petitions that were pending. Paragraph. As far as writ petition civil 11 of 2010 is concerned, the relevant facts are that PPT is a major port trust governed by the Major Port Trust Act 1963, MPT Act, and is now renamed as Paradip Port Authority (PPA) under the Major Port Authority Act 2021 (MPA Act). Full stop. On 3rd August 1985, PPT entered into an agreement with PPL, which was at that point in time a Government of India undertaking. Full stop. Under the agreement, PPL was provided the facility of using a single quotes captive berth unquote at the Paradip port. Full stop. The relevant clauses of the said agreement read as under. This take from page 20. It starts with, whereas Paradip prospects for import of raw materials, machineries, equipments require berthing facilities in the Paradip port. And whereas the next one, the entire whereas, and then clause 1. Clause 4, which is at page 21. You see, unquote. Then you say, it must be noted at this stage that under the MPT Act, a procedure was provided for fixing of scales of rates for services performed by the board. Full stop. Chapter 6 of the MPT Act is titled single quotes imposition and recovery of rates at ports unquote. And section 48 speaks of framing of scales of rates by the Board of Trustees of PPT. Full stop. Under section 52 of the MPT Act, every scale of rates and every statement of conditions framed by the board, open quotation, shall be submitted to the central government for sanction and shall have effect when so sanctioned and published by the board in the official gazette. You also have to set out clause 19 at page 23, apart from those two clauses. Paragraph. At the time of entering into the agreement, the berth hire charges was fixed at rupees 30 lakhs per month. And as regards wharfage, the rate was fixed at rupees 70 per metric ton for wharfage up to 3 lakhs MT per annum, with a reducing scale up to rupees 10 per metric ton, where the wharfage was 12 lakhs MT and above. Paragraph. Till 1993, there was no change in the above rates. Paragraph. On 5th October 1993, in exercise of the powers under sections 48, 49, 50, and 52 of the MPT Act, the Board of Trustees of PPT published scale of rates applicable to all users of the port, including PPL. Full stop. In terms of the revised rates, while the berth hire charges remained unchanged at rupees 30 lakhs per month, the wharfage rates varied from rupees 65 per metric ton for wharfage up to 5 lakhs metric ton per annum to rupees 50 per metric ton, where the wharfage was between 5 and 10 lakhs, and 25 per metric ton, where the wharfage was 10 lakhs and above. Paragraph. It is the case of PPL that it kept protesting against the unilateral action of PPT in fixing the above, revising the above tariffs. Full stop. Since both entities, namely PPL and PPT, were public sector undertakings, bracket PSUs, bracket, at the relevant time, the corresponding two ministries, namely Ministry of Surface Transport and Ministry of Fertilizers, were involved in settling the issues. Full stop. It appears that on 31st May 2000, the traffic manager of PPT handed over the decision of the Board of Trustees to PPL, requiring PPL to deposit the up-to-date interest on all delayed payments in terms of the revised tariff. Full stop. Claiming this to be the trigger PPT filed original suit number 115 of 2000 in the court of the Civil Judge bracket Junior Division, Kojanga, challenging the revision of the tariff notified on 5th October 1993. Paragraph. Since both PPT and PPL were PSUs, their disputes were referred for adjudication to the Joint Secretary, Ministry of Heavy Industries, Department of Public Enterprises, Government of India, on 31st August 2001. Paragraph. While the disputes were pending adjudication, by way of arbitration, by the Joint Secretary, Government of India decided to disinvest its shares in PPL, and its equity shareholding was on 28 February 2002 transferred to Messrs. Juari Agro, a private sector enterprise under the Birla Group. Full stop. With this transfer of shares, PPL ceased to be a PSU. Full stop. Paragraph. It must be noted here that another important change took place with the constitution of the Tariff Authority for Major Ports, bracket TAMP, with effect from 1st April 1999. Full stop. This was done by means of amendments to the MPT Act. Is there a specific section under which TAMP functions?
47 capital A.
I see.
Chapter 5A. Lordships have it, madam. Not can I hand over the book?
Yes, please. Yes, please. By an Amendment Act of 1997, Chapter 5, capital A was inserted in the MPT Act, whereunder in terms of Section 47, capital A of the MPT Act, the TAMP was constituted. This was to be a 3-member body with a chairperson being selected from amongst persons who were presently or had been secretary to the Government of India or held an equivalent post in the central government, and having experience in management and knowledge of functioning of ports. a member, semicolon, a member from among economists having experience of not less than 15 years in the field of transport or foreign trade. And a third member from amongst persons having experience of not less than 15 years in the field of finance, with a special reference to investment or cost analysis in the government or in any financial institution or industrial or services sector. Stop unquote. Paragraph. Consequently, for the period post 1st April 1999, for further revision of its tariff, of the tariff fixed by it, PPT went before the TAMP. Final order of TMP was rendered on 22nd November 2011. Which declined to revise the tariff as claimed by PPT, resulting in PPT filing the second writ petition, Bill 732 of 2012, to challenge the aforementioned order of the TAMP. Full stop. Paragraph. Mr. S.K. Padil, senior counsel, appearing for PPT, submitted that notwithstanding the clause 1 of the agreement, in terms of which the rates were to be, open quotation, suitably enhanced at such intervals as would be mutually agreed upon by the parties from time to time, unquote, comma. Power of the Board of Trustees of PPT to revise the tariff under Section 48 of the MPT Act remain stop. In other words, we submitted that a clause in an agreement between the parties cannot override the statutory power under Section 48 of the MPT Act. Full stop. In support of such contention, reliance was placed on the decision of the Supreme Court in Patiala Central Cooperative Bank Limited versus Patiala Central Cooperative Bank Employees Union, 1996, 11 SEC 202. Full stop. It is further submitted that the arbitrator oblique joint secretary overlooked this legal position in the order oblique award dated 27th December 2002, which decided the issue in favor of PPL. Stop. Secondly, it was submitted that PPL's claim was itself barred by laches. Full stop. It was raised 7 years after the revision of the tariff by PPT on 5/10/2003, 5/10/1993. Full stop. Consequently, on that ground alone, paragraph. Thirdly, it was submitted that with PPL now being no longer a PSU, could not claim parity with other fertilizer companies, PSU fertilizers companies like IFFCO, and compared to the rates fixed for those entities, it would be inequitable to expect PPT to continue to charge the low rates fixed way back in 1985, and which rates have virtually continued till date. Paragraph. As regards the decision of TAMP, declining the proposals of PPT for revision of tariff, it is submitted that PPT was not afforded an opportunity of being heard before the final decision was taken by TAMP. And therefore, its order ought to be interfered with by this court. Paragraph. Appearing for PPL, Mr. Ashok Parjal and Senior Counsel pointed out that as far as the award dated 27th December 2002, as affirmed by in appeal by the appellate order dated 17th March 2009, it covered 1993 and 1990, first April, during which time PPL was in fact the PSU. Full stop. For the period subsequent thereto, the position stood covered by the order of the TAMP, which was a statutory body specifically tasked with fixing tariffs in terms of Section 47 capital A of the MPT Act. Stop. Mr. Parja submitted that the scope of interference by this court in its exercise of its jurisdiction at Article 226 of the Constitution with the decisions of a tariff fixing body like the TAMP was limited. Full stop. It was submitted that only where manifest unreasonableness or arbitrariness is made out, and where there's been a violation of the procedural requirements, can there be interference by the court? Stop. He pointed out that the proceedings before the TMP involved several single courts joint hearings, unquote. And adequate opportunity was provided to the PPT to respond to the counter proposals and submissions of PPL throughout the hearings. Full stop. Mr. Parija referred to the decision of the Supreme Court in Reliance Infrastructure Limited, the state of Maharashtra, 2019, 3 SEC 352, and urged that this court should not interfere with the reasoned order of the TAMP, or for that matter with the award and appellate order of the functionaries of the Government of India, which are challenged in writ petition civil 11 of 2010. Full stop. He submitted that the plea that the claims of PPL vis-a-vis the first tariff revision effected on 5th October 1993 was time barred. Overlooked the fact that the said tariff was not, in fact, put into operation till May 2000, at which point PPL went to the court with original suit number 115. Stop. Accordingly, he submitted that PPL's claims could not be said to be time barred. Paragraph. The above submissions have been considered. Full stop. The agreement between PPT and PPL dated 3rd August 1985 was at a time when the MPT Act was already in force. The stop section 48 of the MPT Act was very much in place at the time the said agreement was entered into. Full stop. Conscious of this, clause 1 stated, clause 1 of the agreement stated that the rates could be suitably enhanced, open quotation, at such intervals as would be mutually agreed upon by the parties from time to time, unquote. In other words, PPT was aware, even at the time it entered into the agreement, that notwithstanding its powers under section 48 of the MPT Act, if it wanted to revise the rates pursuant to the revised rates as indicated in the agreement, it would have to follow the procedure agreed upon by the parties in terms of the agreement. Full stop. Paragraph. The fact situation in the decision in Patiala Central Cooperative Bank Limited, Supra, was different. Full stop. Under section 19 of the Industrial Disputes Act, a settlement between the management and the workmen is given statutory color. Full stop. That provision, that section 19 lays down that a settlement shall come into operation on such date as is agreed upon by the parties to the dispute. And if no date is agreed upon, the date on which the memorandum of settlement is signed by the parties to the dispute. Stop. It is in the above context that the Supreme Court was called on to answer the question whether the agreement could be enforced even if it was contrary to law. That is, even if it's contrary to law. Full stop. The court noted in that context that the binding effect of the agreement was in fact provided by section 19(2) of the ID Act, which also laid down the period during which the agreement would be binding, notwithstanding the notice of termination given by one of the parties. Full stop. It was then observed by the Supreme Court as under take paras 32 and 33 paragraph. The context as far as the present case is distinctly different. Stop. There is no mention made in section 48 of the MPT Act of any agreement between the parties at all. So in other words, section 48 appears to operate in a field independent of an agreement between the parties as regards fixation of tariffs. Full stop. At the same time, there is nothing in section 48 of the MPT Act that prevents parties from entering into a different arrangement for fixation of rates. Full stop. Interestingly, there is no non-obstante clause in section 48 of the MPT Act, which would give precedence to the rates fixed thereunder over the rates fixed in terms of an agreement between the parties. Full stop. Therefore, unlike section 19 of the ID Act, the legislative intent behind section 48 does not appear, of the MPT Act does not appear to give it precedence over tariffs that has been fixed pursuant to a mutual agreement between parties. Stop. Consequently, this court is not persuaded that the decision in Patela Central Cooperative Bank Limited is relevant as far as the present case is concerned. Paragraph. both the award dated 27th, full stop. As far as the plea of laches is concerned, the court finds that in the original award oblique order dated 27th December 2002, reference is made to the claims preferred by PPL, the counterclaim of PPT, and on that basis, the learned arbitrator framed 5 issues, none of which pertain to limitation. Full stop. When the matter was taken in appeal, there does appear to have been submissions pertaining to limitation. Full stop. Nevertheless, the appellate authority appears to have accepted the plea of PPL that open quotation on the appellant's bracket PPT bracket own showing the cause of action has arisen in May 2000 and the reference of disputes to arbitration has taken place well within a period of 3 years from the said date of reckoning. Full stop, unquote. Paragraph. PPT does not appear to have insisted upon payment by PPL of the revised tariff till 2000. Full stop. It must be noted here that at that point in time, both PPT and PPL were PSUs. And it is definitely plausible that the corresponding administrative ministries were negotiating for a settlement of the dispute. Full stop. Consequently, this court is not persuaded that the arbitrator ought to have rejected the claims of PPL as being time barred or barred by laches. Stop. Paragraph. Even on merits, the court finds that there's a very detailed discussion in both in the order oblique award dated 27 December 2002 as well as the appellate order dated 19/10/2009 of the basis for fixation of the original tariff and the revised tariff, while accepting the claims of PPL in that regard. Full stop. The fact that PPL had itself constructed the berth which was to be exclusively used by it and which was acknowledged in the agreement dated 3rd August 1985 was taken note of both by the arbitrator as well as the appellate authority in accepting the plea of PPL regarding fixation of the tariff that appeared to be concessional as far as PPT was concerned. Stop. The court is not persuaded that on merits, either the award dated 27/12/2002 or the appellate order affirming it call for interference. Paragraph. As far as the period after 1/4/1999 is concerned, that is the period during which PPL ceased to be a PSU, the court has carefully perused the impugn order of the TAMP dated November 2011. Full stop. Placed on record as part of the writ petition is also a detailed proceedings drawn up by the TAMP. On 29th November 2010, where in paras 3 and 8, a specific reference is made to the joint hearings held with both parties by the TAMP. Stop. Further, reference has been made to the submission of proposals by PPT, the requisite documents, the comments made by PPL on PPT's proposal, the forwarding of those comments to PPT for its remarks, and setting out in tabular form the respective stands of both PPT and PPL, as well as the specific replies given by them to the queries of the TAMP. Stop. In other words, spread over several hearings was a joint deliberation by the TAMP with the parties on the proposals and counter proposals for the purposes of fixation of tariff. Full stop. A bare perusal of the order dated 29/11/2010 reveals that what was undertaken was an elaborate exercise of tariff fixation, taking into account a variety of factors that would have relevance for the exercise. Full stop. It was truly the work of an expert body, specifically tasked with tariff fixation in terms of Section 47 capital A of the MPT Act. Full stop. Paragraph. Then we have the final order dated 22nd November 2011. Full stop. Mr. Padi emphasized on paragraph 5 of this order, which reads as under, reproduce paragraph 5, pages 273, 274. Stop. He accordingly submitted that there was a denial of personal hearing afforded to PPT before the final order was passed. Paragraph. A perusal of the above paragraph shows that it refers to all the steps that were gone through before arriving at the final determination. Full stop. As correctly pointed out, both parties had undergone the process of mutual consultation between them, and the minutes drawn up of the earlier proceedings reflected both their views. Full stop. It was in that context that the TAMP considered it not necessary to afford a further single court's personal hearing, unquote, before the final order was passed. Full stop. This is not to say that there was no hearing at all. Full stop. In fact, as already noted in the TAMP's own order dated 29 November 2010, there were joint hearings on several dates and exchange of information between the parties and deliberations thereof. Full stop. Consequently, it is not possible to accept the plea of PPT at this stage that it was denied an opportunity of being heard before the final order was passed by TAMP. Full stop. Paragraph. Indeed, the scope of interference by this court in its jurisdiction with the decision of a tariff determining body is limited. Full stop. In a similar context, while reviewing the decision of the Maharashtra Electricity Regulatory Commission bracket MERC, the Supreme Court in Reliance Infrastructure Limited Supra observed as under para 38 and 39. PPT has not been able to persuade this court that the impugned decision of the TMP suffers from any manifest arbitrariness or unreasonableness. Or that the procedure as envisaged under the MPT Act, and in particular section 47 capital A thereof, has been violated. Good stop. Consequently, the court is not persuaded that any grounds have been laid out by PPT for interference with the final decision dated 22nd November 2011 of the TAMP. Paragraph. For the aforementioned reasons, the court finds no grounds made out for granting any of the reliefs prayed for in these writ petitions. They are accordingly dismissed. The interim orders are vacated. No order assistance.
Well, at page 480, there was a direction. The Supreme Court had said, my lord, it had clarified that if the award is clarified in case the award is upheld, the High Court shall ensure that it is executed without any delay. So one line, page 480.
Right. You say at this juncture, the court notes that in its order dated 12th January 2016 in SLP Civil number 14811 of 2009, bracket Pradeep Phosphates Limited versus Paradip Port Trust, bracket, the Supreme Court had noted that open quotation, in case the award is upheld, comma, the High Court shall ensure that it is executed without any delay. Full stop, unquote. It is accordingly directed that PPT will implement the award within a period of 12 weeks from today.
Let me grant me 3 months time. Then all
yeah, 12 weeks. 12 weeks I've said. 3 months.
Fair.
Right.
Pastor matter item number 46.
Your Lordship, last token directed to examine whether this is the coming under the purview of the limit of the CBD for order of the cases. No? But as it appears not the in the appellate authority order, the assurance is not 55 crores 97,000 97 lakhs 53,274. It's more than 1 crores.
We are still in the IA, is it? It's not been allowed, is it?
No, it has not been admitted because the Honorable Court earlier directed to examine whether the tribunal judgment of the Hyderabad High Court, whether the revenue has filed any appeal or not. That has not been, Lord, I ascertain that, Lord, I am not able to ascertain that. However, Lord, these cases slightly different so far as Raju, the case of the Income Tax Appellate Tribunal, UNA Raju Construction. There, my lord, if your lordship see kindly for a moment, see.
So the tax effect is more, is it?
Yes, your lordship. But here the tribunal only said that there is no contractual obligation so far as the AV and the other contractor, my lord. If your lordship see the for a moment, my lord, running page 89, it is clearly visible that there is a contract, though there is no written contract, but later
No,
itself.
how are you, first of all, how are you calculating the appeal effect?
My lord, your lordship see the disallowance made by the assessing officer, which has been confirmed by the appellate authority. You'll also see the running page 61. You'll also see for a moment, see not. That is two amount is mentioned, Lord. Hmm. 54 lakhs 9753. It was transferred to a contractor. The revenue stand is that he has not deducted in tax under 194C of the Act. Therefore, 40AI is applicable. But court, my lord, the Honorable Tribunal says, my lord.
See, why the question was posed to you was because of the first question at page 16, bottom.
Is no, that is not that not.
No, what you're referring to is question 2, is it?
Yes, question 2 and 3, Lord. It is declaratory, Lord, legislation. Therefore, Lord, I say, Lord, it will be applicable to retrospective effect, Lord. And more similarly, tribunal finding is that the revenues could not brought to the notice that there is a contractual obligation between the JB and the contractor. Therefore, let's see the one pages, that will clarify everything. That is my running place 90 of my appeal memo. And I'm not saying, Lord, you will also know the JB is a separate entity and the contract is a separate entity. You will also see the starts from 90 and the next page you will also see. While following the term and condition applied, ask for this letter. Clause 4 is relevant, Lord. Tax and other duty will be applicable to ask for the government PDS and WCT. Therefore, my lord, this letter itself specify that the person who has been executed the contract, Lord, the person, Lord, who is alerted, he has to deduct the tax as per term of 194C of the Income Tax Act. And therefore, Lordship, yet to admit, but your Lordship directing me to examine whether it is commonly limit of.
Or Mr. Satpathy states the monetary, the tax effect is beyond above the monetary limit. Since what is being urged is questions Roman small 2 and Roman small 3.
Yes.
Paragraph. Notice confined to questions 2 and 3. Bracket as set out in page 17 of the memorandum of appeal. Bracket. Returnable.
Your Lordship, Saswat Ajay is appearing in this case, Lord. His earlier morning today is, your Lordship has not issued notice, your Lordship.
There he is. Mr. Acharya accepts notice. List on 12th July.
Because name of Sanjay Acharya, because his father was earlier this instance. That may be deleted.
The name of
and my name
Mr. Acharya being shown for the respondent.
Well, it's only there's a certain development. One of the GE constituents is under CIRP.
Oh, I see.
So
Okay.
whether this appeal can even proceed belongs due to moratorium.
But it's only one JV partner, not the JV itself.
No, it's the JV. Yes, one JV partner is under CIRP.
So that may be a question of law you'll have to examine.
Yes.
Much obliged.
All right. Yeah.
Weekly list. The memo is issued for withdrawal.
Excuse my lord. Two matters, my lord, covered by your lordship's judgment, my lord. Narottama Ratha. My lord, item number 93 and 175.
All right. 93, 175.
And 175. 76, my lord. There is the, my lord, the.
No. What is the correct number, sir?
176 and 93.
Sir, again, you're telling me different numbers. Give me slowly, carefully, give us the correct numbers.
My lord, WPC number 20344 of 2014. That is the item number 93.
93. And then which is the other one?
Other one, my lord, 176, WPC number 23157 of 2015.
All right. 93 and 176.
And my lord, in that second matter, my lord, WPC number 23157 of 2015, sole petitioner died. And to that effect, my lord, one IA has been filed already on your lordship's record.
Substitution is allowed. All right. Taken on board. Maybe that. All right. Taken on board.
My lord, I will kindly pardon, my lord. My lord, item number 117, 118, and 119 are also covered under judgment of Narottama Ratha.
All right. 117, 118, 119, Narottama Ratha. Okay. Then these memos.
May I call it?
My lord, pardon to mention, my lord, item 57, my lord. It is also covered matter, my lord.
50?
So cancellation matter.
Item number.
Item 57.
All right.
The memo issued, item number 58.
Item number 176. Consolidated cost title, my lord, filed in course of the day. It's on record, my lord. Consolidated.
Item number 58. Item 63. Item number 64. Item number 67. 72. 74. Item 81 and 132 weekly list.
All disposed of as withdrawn in terms of the memo. All right.
I mean, pardon me, Lord, in item 67, I am appearing for the workmen 4 to 6 million.
All right.
The petitioner has given the memo.
All right.
But my appearance may be noted.
Yes, please. Yes. All right.
So, 25.
25, my lord, the Marfadar appointed now is to be substituted. But he was already a pro forma opposite party. This is an endowment, a public endowment.
All right. So for the reason stated therein, the application is allowed. And Mahanta Raghuveer Das of Balaram Kota Matha, Puri, is permitted to represent the deity Shri Lakshmi Narayan Dev and Shri Satyanarayan Dev. BJ Balaram Kota Matha, Puri. All right.
Permitted to make the correction in the
the consolidated cost that will be filed within a week.
Yes, sir.
All right. So what happens next? I mean, do we go ahead with the hearing or?
Yes, yes, if my lord. But this is a matter where my lord, my lords reviewed the order earlier. Passed by my lord, the Chief Justice and my lord VP Rautrai. What had happened, my lord, we had specifically stated that the Consultation Commissioner, Consultation Authority had already decided my favor, my title. I was noticed nowhere, my lord. 5A, 6, 9, even the award. In 30, my lord, they brought in our name.
Okay.
Because they had the bona fide impression. So thereafter, my lord, they took instructions and came back with instruction that admittedly the right title interest has been decided at the Consultation Authority. No appeal has been filed or revision has been filed. That's the short point, my lord. And therefore, the entire land acquisition proceeding, qua the DT has to go, my lord.
Here, my lords, Firstly, my lords, on laches, my lords, because the acquisition, the 4-1 notification is 1997. They come in 2003, my lords. The Supreme Court is clear that if there is a delay, my lords, in challenging, because my lords,
Where's the award passed?
my lords, the award was passed in 1998, my lords.
Oh, I see.
1998, and my lords, now, my lords, the issue is only the apportionment of the compensation. It is gone beyond the Section 12 stage, my lords. And IDCO, my lords, is the authority which has taken over the possession, my lords. At least paper possession. They say that at least the last position is, as per them, is that they still have possession. But IDCO has been given paper possession, my lords.
No, but the point that he was not heard, what do you say to that?
My lords, so that effect, my lords, in fact, my lords, public notices and all were given. So,
no, they were not made parties. They say they have not made parties.
Anywhere, man. The first time they made us a party is in the 30 when the apportionment was supposed to be made.
But can we change the whole thing? We can't. See, once an award is passed. And
Yes, my lord. The award has passed, my lord. The award is passed, my lord, saying that it is our land. That is why it's a nullity. But they say, the acquisition proceedings, they say that it is in our khata, in the government khata. So where's the question of acquisition, my lord? They have missed away the fact that the ROR at that given point of time was also with the deity. That is what the revenue authorities have missed out.
No, so if it is Section 30 stage, then obviously compensation was determined.
Please, my lord.
Yes, my lord. If the acquisition is good, my lord, I have no quarrel. My lord, the acquisition cannot be done because of the fact that nowhere throughout, my lord, as notice has been issued to the person who is a recorded tenant. That's the problem, my lord. Right through. And for the first time, they bring us in, my lord, admitting the fact that I'm a recorded tenant at the 30. Then, my lord, I should demonstrate that we were recorded tenant from 1927. And that has been recorded by the consultation authority. That has gone unchallenged. Unfortunately, they are not seeing that, my lord. So we were 6 to...
No comment. Notice was issued to the commissioner.
And my lord, commissioner, my lord, 69, my lord, if it's a public charitable public authority, my lord, the DT, my lord, the endowment commissioner has to be necessarily noticed under 69. If I am a DT, my lord. It's a perpetual minor, my lord.
My lords, may see my counter affidavit, my lords, para 8, my lords. Because, my lords, they say that the award does not mention the name of the tenant, my lords.
Recorded tenant.
Recorded tenant.
Yes.
It is humbly submitted herewith that the award has been framed on the volume of the land acquired. The title holders are not believed to be true owners of land since they have fraudulently acquired such title in 1977 settlement.
How do you say this? On what basis? How do you say this, please? In fact, if they have been sent notice in the Section 30 proceedings,
please,
how can you turn around and say that they've fraudulently acquired the land?
Millers, in Section 30, Millers, it's a competing claim, Millers. They are
No.
The apportionment, Millers.
Government does not pay for its own land.
No.
Correct? So the fact that some compensation has been deposited in the court means the beneficiaries can't be the government itself.
Please, Millers.
It's an acknowledgement that there are private owners.
Please, Millers.
And then for apportionment, you have Section 30 and you should notice.
Please, Millers. Millers, with regard to this contention, there is no document, Millers, to support. That is.
In the meantime, my lord, for whom it was acquired, my lord, they have surrendered to the revenue. The IDCO has surrendered to the revenue. The land acquired.
Has been surrendered by the revenue?
Yes, my lord. They have surrendered to the revenue. IDCO said we don't want it. Interestingly, my lord, we kindly see the consultation order, which I have annexed, my lord, and in the review, therefore, my lord, directed that since this matter was not looked into, my lord, and therefore, whether I have, in fact, There's a challenge to that. No challenge to that is there. They file an objection, my lord, the revenue files an objection before the consultation authority that from 1927 it is in the DT's name, that cancel and give it to us. That the consultation authority says, no, they are the recorded tenant. They have been having the record of rights from 1927, so you cannot take it away. They don't, that goes unchallenged.
That's in your additional affidavit, is it?
No, ZIPCO has also filed its affidavit.
Page 72 is consultation order.
Page 72, my lord, is the consultation order, my lord. That is the reason, my lord, recalled the earlier order.
Page 70.
But if we allow this, it will open up a whole Pandora's box, isn't it?
This is the only one, my lord, there. All the others, my lord, there is no other case. And we are in possession, my lord. And the last, even subsequent to their acquisition proceeding, record of rights have been recorded in our favor. The record of rights are in our favor, even, my lord, post their so-called 4 application and 6 and 7, 6 and 9 and all others. Still I continue, my lord. This, my lord, the objection is filed by them in 2005. The acquisition proceeding is initiated on
1997.
1994. 97 they do it, my lord. 2005, 15, 5 it's decided in our favor. They file an objection then, after the land acquisition proceeding is initiated.
$95 acres.
Please, my lord.
Yes, in 93 acres, my lord.
Total is about 367 acres, out of which they have about 95.
All others are, my lord, there also I don't know what the situation is, my lord. We are only concerned is 93
Is there a temple on this? What is there? Is there a temple or is it vacant or what is it?
It was, we had, my lord, it was cashew plantation, which they had, my lord, they had, in fact, the IDCO had auctioned at one given point of time.
No, because this, I think, is closer to this airport, proposed airport.
No, my lord. It's just the opposite side. My lord, that after the, my lord, that Sterling Resort, in the right, that Daya River is there, it's in the other side. This, my lord, is on the left side. My lord, what is there is that Tosali sand side, the other side. My lord. That is where the airport is also. They're again having, my lord, relooking at the matter because of the fact that it's a very area which is prone to cyclone. So whether they will do that or not, also they're not very sure.
Whether the airport will be located.
Yes, my lord.
Well, it's because this was, the proposal was for a tourism.
Yes, and they have done away with.
That was the proposal. And it covers the public land.
No, in the ultimate analysis, it's only about compensation, right? If they want to acquire under Section 4, you don't have any objection.
No, my lord, if at all, my lord, in the other states, my lord, they have put in at 4 also notice to the.
No, that's right. I'm saying the end result of all of this is that you will have to be heard in the land acquisition process.
Yes, land acquisition, but 2013 Act, my lord. We have no problem over that. They have to initiate in 2013 Act.
Do you want to
fair price?
Take instructions?
I'll take instructions.
Yes,
because this will have
Because you can even go in for a private purchase then.
Yes, that's right, madam.
Depending on how badly you want the land.
They in fact don't totally want the land now.
Puri land is so precious.
Yes, no, my lord, this is that part which was being sold very reasonably priced, my lord. That time, my lord, because that still there, that river doesn't have a connection.
I see.
So therefore, they were all barren land. I mean, and these are the first people, initiation of the people of this mutt, my lord.
All right.
And it's an endowment.
The challenge in this petition is to acquisition of land measuring AC 95.13 decimal in plot numbers 239, 239 by 502, 239 by 503 under Khata number 128 in Moja, Sipa Sirubali in district of Puri. Full stop. The petitioner's claim is that despite being a recorded tenant, the petitioner was not made a party to the land acquisition proceedings under the Land Acquisition Act 1894, bracket LA Act. Even after the stage of the passing of the award, so it is claimed that only at the stage of apportionment of compensation under Section 30, in proceedings under Section 30 of the LA Act, was notice issued to the petitioner. Initially, the court had dismissed this writ petition by an order dated 12th August 2021 on the ground that the petitioner had not been able to convince the court about being the lawful owner in possession of the land in question. Subsequently, in review petition number 171 of 2021, 171, 172 of 2021. This court, when ordered 11th March 2022, recalled the earlier order. Stop. The reason for recall of the order was that there was an order by the Consolidation Officer Puri in favor of the present petitioners in objection case number 2567 and 2568 of 1996, which had attained finality and which order had recognized them to be the recorded tenants.
1927, man.
Since 1927.
And we had the ROR also right through.
The learned AGA confirmed to this court that the said order had not been appealed against by the state. Accordingly, this court recalled the earlier order dated 12th August 2021 and set down the writ petitions, the restored writ petitions for hearing. Paragraph. This court has heard the submissions from Mr. Yashobhan Das and Senior Counsel for the petitioner and Mr. Mohanty Learned, Additional Standing Counsel of the State. Paragraph. It transpires that even if the court were to accept the plea of the petitioner and invalidates the proceedings under the LA Act, it would still be open to the government to initiate fresh acquisition proceedings. But this time it would have to be under the 2013 Act. Full stop. The other factor that requires to be noted is that the land in question is to an extent of AC 95.13 decimal. And in Puri district, full stop, the state would have to make it stand clear whether it still requires the land And for that purpose, is it willing to follow the procedure now under the 2013 Act? Mr. Mohanty seeks time for instructions. At his request list in the main list on April 3rd.
They'll take it, sir. My lord, I've directed them that if they want to acquire the land. I have no problem over that one.
Correct.
That power they have always.
Right.
Weekly list. Item number 37.
Your Lordship, on behalf of learned senior advocate Narendra Kishore Mishra, this matter may come on Monday, Your Lordship.
Sir, I am for the opposite party.
Why Monday, sir?
Your Lordship, the learned senior advocate is now on his feet in another court, Your Lordship.
We'll just stay on board. Doesn't have to be adjourned by a week. We'll pass it over. Ask him to come whenever he finishes. Yes.
Your Lordship may keep it for tomorrow.
You ask him to come whenever he finishes. Yes.
Item 38. Item number 38.
None of it.
Item number 39.
None of this dismissed.
Item number 40.
OGLS matter, Your Lordship, here in the petitioner seeks to challenge the resumption case initiated by the authorities, Your Lordships. Your Lordship. Lordship, may kindly have a glance at the annexure to Your Lordship. Without my main contention is that the proceeding initiated by the authority is beyond limitation, Your Lordship.
Are you a subsequent purchaser or the original tenant?
Original lazy, Your Lordship.
My lords may see the impugned order, my lords. Page 11. Second paragraph. This is a resumption case under 3B of the OGLS Act. The Honorable High Court, Orissa, while disposing of the writ application by judgment and order dated so-and-so, called upon the state government to inquire into the matter through a senior officer in the rank of secretary, and on inquiry, if it comes to light that the Tahsildars by misuse of powers have settled the land, then necessary legal and administrative action should be taken against them. And further, if the lands so settled are used otherwise other than the purpose, the government should proceed against the lessees in accordance with law. Then,
in accordance with law is very important, sir.
Yes, thereafter, the matter was referred to the Law Department, and the Law Department have clarified that the direction of Honorable High Court relates to resumption where land has been used for purposes other than that for which it has been settled. Such resumption falls within the purview of Section 3B of the OGLS Act, for which no period of limitation has been prescribed. Accordingly, it was decided in the Revenue and Excise Department, Government of Orissa, to deal with the 1,578 cases pending with the ADM. ADM Khorda, come Settlement Officer, Cuttack, under Section 3B of the OGLS Act, and it was instructed with a Revenue and Excise Department so-and-so to transfer these cases and entrust to the additional Tahsildar to initiate action under 3B of the OGLS Act. And accordingly, wasteland lease cases were instituted.
Lordship.
Thereafter, on the notice issue for expeditious disposal of the pending resumption cases and in view of difficulties being faced for the service of notice.
This is the shortcut. That's why many of the individuals don't get notice at all. When this court said do it in accordance with law, you devised a further shortcut. You said newspaper is enough. Who's reading newspapers?
And pursuant to that, a lot of recorded tenants have also appeared, and that
but when the order was passed, they were not made parties. Yes, correct. These are the short ground on which the petitioner challenges the impugned order dated 29th August 2002, passed by the Additional Tahsildar Jatni in WL case number 1591 of 1981 is that the petitioner was not heard before the said order was passed. Paragraph. Perusal of the impugned order reveals that it was triggered by the observations made by this court in a judgment reported in 81 bracket 1996 bracket CLT 513. Stop inter alia, this court had directed the government to resume the lands illegally allotted, and for that purpose to invoke Section 3 capital B of the OGLS Act 1962. Paragraph. The state appears to have devised a shortcut as far as service of notice under Section 3 capital B of the OGLS Act is concerned. To stop such notices necessarily had to go to the persons in current occupation of the plot in question, or who were the recorded owners of the plot in question. Full stop. Instead, the state appears to have simply brought out an advertisement on the resumption of those cases in one Oriya daily newspaper. Paragraph. This can hardly be satisfy the requirement of notices having to be served on the recorded owners individually. Full stop. Considering that the proceedings themselves were initiated fairly belatedly, and that to pursuant an order passed with this court, referred to here and before, bracket, individuals unconnected with those proceedings cannot be expected to become aware of the proceedings under Section 3 capital B of the OGLS Act by merely seeing a newspaper. In any event, since the petitioner has now appeared before this court, no proceedings can take place without his being made. He's being heard by the Additional Tahsildar Jatni. Paragraph. For the aforementioned reasons, the order dated 29th August 2002 of the Additional Tahsildar Jatni setting aside the lease sanction, let's add lease case number 1591 of 1981. Is hereby set aside. Matter stands. The aforementioned wetland lease case number 1591 of 81 is restored to the file of the Additional Tahsildar Jatni, where it will be listed for hearing on 1st March 2023, when the petitioner herein will appear along with the downdated copy of this order. Full stop. The Additional Tahsildar will endeavor to expeditiously dispose of the case, preferably within a period of 4 months from that date. Full stop. Till then, status quo shall be maintained vis-a-vis the land in question. Full stop. The petition is disposed of.
Oblige your lordships. Item 41.
We just need to add 1 minute. Oh, it's not in this. All right. No counter was filed in this, right?
No.
All right.
Item number 41.
None appears dismissed.
Weekly list item 42.
Your Lordship, on behalf of Mr. Swain, no instruction.
No instructions dismissed.
Weekly list item 43.
May I please, Your Lordship? And in this case, initially the petitioner who was the original lessee was allotted. Now he, after his death, during pendency of the case, he has already died, and his legal has already substituted, my lord. And he was allotted 100 decimal of land for homestead purpose, And your lordship kindly see the impugned order, not impugned order, that is also remitted back. The order of ADM, page 11, paragraph, last paragraph, your lordship kindly see. However, the OP appears to be a landless, homesteadless SC person of the concerned village. He also does not appear to have any profitable means of livelihood. Therefore, he might be an eligible person. But in view of the materials and the technical irregularity noticed, what is the technical irregularity does not reflect in the order sheet itself. But this proceeding was initiated and the entire inquiry was made in following the 74 amendment rules, which was not came into effect at the time of allotment because it was allotted much prior to that in the year 1972. And thereafter, as such, the matter is remitted back to the Tahsildar Bhubaneswar with directions to cause fresh inquiry into the matter and to dispose in accordance with the law, restricting the area to 40 decimal, my lord. To reduce the direction to reduce the area 40 decimal, as to why does not know. However, the petitioner paid rent revenue in the year 1988. The order was passed in the year 1987. Petitioner paid the rent revenue in 1988. Thereafter, Tahsildar did not accept the rent revenue till final order. After 11 years, lordship kindly see that page 4, page 14, annexure 4, notice was issued by the Tahsildar in the year 1998 to verify the records. Thereafter,
So this ADM's order, you were not made a party?
My lord?
In the ADM's proceedings?
Yes, I was a party. I filed the written statement. And this is also supported in favor of the petitioner. But direction was made to the Tahsildar to make an inquiry and to press, and eligible title is there.
So why should the interfere? It's only gone back to the Tahsildar, right?
That Tahsildar is still no order has yet been passed.
Okay, that you have to file contempt.
You also kindly see now 50 years already expired. In portion, the annexure 5 is the permission after obtaining the necessary approval of a permission. The petitioner already constructed their house, the entire land, my lord. And they are not accepting the rent revenue and no order has yet been passed.
That's okay. No order being passed, you have to have other remedies. And filed a contempt.
Annexure 5, my lord, your lordship can see. Annexure 5, that is the BDA approval, and he constructed after his death and his son and widow are living. Your lordship can see 72, 74, there is also settled principle of law held by this Honorable High Court. Inquiry made under as per the rules 74 does not applicable in the present case as because the lease was granted in the year 1972. So 74 rules does not applicable in this case, my lord. And the initiation of proceeding itself after 14 years, your lordship is directed in a number of cases. After 14 years, initiation of a proceeding it does not also lie sustainable in the eye of law. So now 50 years already expired. Lordship kindly directed the Tahsildar to accept the rent revenue and to effect the mutation in favor of the petitioner, my lord, because he is their only widow mother and son is living there.
Yes, sir.
Well, I have received some instruction. If I may read, my lords. It is humbly submitted that government land with a subject khata numbers so and so was leased out in favor of Shri Ghansham Shetty in WLL case number this. It is found from the lease record that the then additional Tahsildar had taken up the matter after case is remitted back from the ADM, and after examining the lease and perusing the field inquiry report from the revenue inspector, the lease is resumed and restored to government khata. Nothing
else, no counter have been filed as yet.
If Milas gives a week's time, I'll put this in affidavit along with the copy of the wasteland.
What
lease.
does the affidavit say?
This is the instruction I've received on 7th of December.
No, what does it say?
Well, it says that after Millards, it was remitted back from the ADM. Millards, the Tahsildar has inquired into the matter, and basing upon a field report by the revenue inspector, the lease has been resumed to the government khata.
No, an order has again been passed.
Yes, Millards.
He says nothing has been done.
What is that order, my lord? When?
Millards, let me put it on affidavit.
Mr. Mohanty states on instructions that on remand by the ADM, the Tahsildar has again decided the matter against the petitioner.
Please,
copy. The counsel to the petitioner, however, claims that he has no knowledge of such order. A copy of the said order be served on him within 1 week.
Yes.
List on. If that's that order, then you have to go and appeal.
No, my lord, nothing, because here your lordship can decide what order, they will create the order, manipulate the order. Because as for the night.
All right. 29th March in the regular list.
Weekly list item 44.
No such addressee.
My lord, item 44. Your lordship wanted one affidavit from the learned additional government advocate and service return OP number. I'm so sorry, my lord. The lord, your lordship wanted here for service of notice on the opposite part number 2. Lord, in fact, they say that there is no such addressee. My process has come back.
Yeah.
I am to make a paper publication, Lord. Otherwise, he is the workman, he will be ultimately affected here.
The notice to the respondent has been returned unserved with the remarks in the no such addressee. Unquote. Mr. Rathas states that he will take steps for substituted service on OP number 2.
So file the draft within 2 weeks, my lord, or 1 week.
I just keep it on board and then meanwhile you can.
As your lordship pleases.
21st March.
Lord, within that period, I'll complete it.
Item 45.
21st March in the main case.
Item number 45.
May I please, your lordship? My lord, water body.
1 minute. In the
Bhubaneswar, about
1 minute, 1 minute, sir. In that item 43, you have to say that the MC number in order number 4 dated 23/11/2022 should be shown as 10760/2020. Yes, now
45.
Yes, tell us.
My lord, about 3 acres of land in Bhubaneswar near this Kalinga Stadium, my lord, recorded as Hrodo, Jalasaya, my lord. That has been gradually sold illegally by which belong to my lord Deti Saraswati Dibe Vijay, my lord. Illegally sold by the Didar Marfatdar in favor of 2 builders, opposite pattern number 4 and 5. And
5 has refused service. I don't know about 4. Anyone appearing for 4?
My lord? 4 and 5.
4 and
5 has refused service. Is anyone appearing for opposite party number 4? That's the question I'm asking. Right.
I am for the opposite partner 5.
I see. So you have now decided to appear. You refuse service. That's the endorsement here. Yes. What is your stand? Opposite party number 5.
Yes, because here their claim is this property is the property of the deity. They are saying, but they already a proceeding under 25 of Odisha Hindu Religious Act has already been initiated before the Endowment Commission. That is pending there. A status quo order is also operating under section 7 of the Act.
Status quo has been passed by this honorable court.
Yeah, this court passed the status quo order, sir, 12th April.
Yes, Lord. Some public has already initiated a proceeding under section 25 of the Act, Lord, Poichari Act, and there they have filed an application under section 7, wherein status quo order is also operating. In one point of time, I challenge the proceeding under section 25 before this honorable court. and this Honorable Court was pleased to quash the proceeding. Thereafter, a civil appeal was made before the Honorable Supreme Court, and the Honorable Supreme Court remanded the matter again for the fresh consideration that is pending there. So all the disputes are pending before the Endowment Commission.
All said and done, my lord, a water body which is not available to be sold. That is the primary question before my lord.
No, but why so many forums should be dealing with the same issue?
Because they had approached them earlier, my lord, for which we came before your lordship in 2013 and your lordship granted protection. And all these blends
No, but if, proceedings are already under which act? OPLE.
No, it is the Odisha Hindu Religious Endowment Fund.
Which,
what are those proceedings? What is the number? Where is it pending? Commissioner?
Commissioner, your lordship.
Commissioner Endowment.
So why don't you take up all these issues there itself?
That is numbered as OA number 86 of 2008.
That is with respect to, my lord, other aspects of it. But question now is, how this Jalasaya property, my lord, your lordship is aware of that. It cannot be sold. And
so let the commissioner deal with it.
I don't know whether that aspect can be decided by the commissioner
Why
or
not?
not.
In fact, every time they apply to the commissioner only for permission to sell.
It's not a question of simplicity, my lord, sales. The question is, my lord, the property once it is recorded under that category, whether it can be sold. And our High Court says no. Jalasaya land cannot be transferred.
That question can be adjudicated by the commissioner.
As probably the endowment commission's lawyer counsel could apprise this.
She appeared on the last occasion. If your lordship had look at the order,
this matter was listed last
21/11/2022, she appeared the other day.
Yes. 18/10/2022 was the last time the matter was listed before the endowment commissioner. So,
So it's still pending there, sir.
Yes.
Here, no effective hearing has taken place.
No effective hearing. That's your lordship's right.
Only one status quo order on
29/9/2022, when the matter was taken up by your lordships, Mr. Mahanti appearing for the state said that I will file an affidavit because state is concerned in that. Thereafter, matter was listed before the other bench, my lord, headed by Justice Sinha. There, all of them have appeared. Like my lord, this Miss Naidu appeared, and so also. And there the registry sent notice to opposite party number 5 because he was not appearing earlier.
Anyway, he's now appearing.
Now he's appearing. So what I pray, my lord, let this issue be decided. That can be decided whether this property can be sold or not.
Yeah, let the commissioner decide it.
Please.
It is informed by opposite party number 5 that proceedings are already pending before the Commissioner of Endowments. In what's the case number?
Well, it's OA number 86 of 2008.
In OA number 86 of 2008, paragraph. The prayer in the present petition concerns the same deity, and the petition seeks to restore to the deity the land classified as single quotes Jalasaya Hrada, unquote. Full stop. The court permits the petitioner to intervene in the proceedings stated to be pending before the Commissioner of Endowments to raise the above plea. And if the intervention is made not later than 1st March 2023, the Commissioner will, after hearing the petitioner and other necessary and proper parties, pass appropriate orders on the petitioner's application within a period of 4 months. Paragraph. No further directions are called for. The petition is dismissed.
Your lordship, that Jagpal Singh case, my lord, where this Hroda and all
You
that.
don't have to mention all that. That you raised before the commissioners.
And I am told, my lord, I have some noting here that apart from that, what is my learned friend mentioned about the case number, there are other cases also.
It's all right. Whatever. Yes.
Item 46. Item 43, your interim order to continue, my lord. Item.
Yes.
Item 46.
May I be the lordship? So in this case, the petitioner has assailed the improved order annexed 7, page 36 and 37. That the petitioners are landless person, they are possessing the land for which inquiry conducted by the Didan Tahsildar and settled the land only 4 distinct blocks. In 2004, White annexed 3 million. Thereafter, Indira Avasa Group has been constructed over the land miller. And after expiry of 8 years, now another appeal was preferred by the Didan Tahsildar to cancel the land on the ground that petition not landless person. My submission there, land was allotted in favor of the father of the petitioner number 2 to 5, but they are in 2008 they died. Thereafter, no notice was issued by the Tahsildar against the legal heir of the person, my lord. In the appeal which I preferred in 2012, my lord. Now, behind and back of the legal heir of the lessee, now the appeal has allowed and restore the land, try to restore the land in the government khata, only 4 disputes. Now, the legal heir of the allotee or lessee has not been implemented party in the encouragement appeal unnecessary. Even if the allotees were died in 2008, appeal was preferred 2012. No notice and served against the legal heir of the party. Only 4 distinct landmarks.
This, who's appearing to the other side?
That's 46. The copy has not been served. We don't have copy.
2013 matters. Please serve a copy. It will stay on board. Anyone else? Any covered matter? Withdrawal? Anything?
Item 51, my lord. It's covered. OGLS matter covered by Lordship's judgment.
Narottam Arata. Item 57. 51.
Let's come. I will solve the copy.
Lordship, item 107 is no instruction.
107, no instruction.
Lord,
I'm appealing through VC.
52.
54, I'm appealing behalf of the opposite party number 2. I have some personal problems tomorrow. Just for 1 day accommodation.
Who's with the petitioner?
This matter has been listed for the last 3-4 days, but it's not.
No, but you've not filed any counter anyway.
No, Milad, this is an order.
You're there in this matter. 52, is it?
54.
54.
56. 56.
56.
Milad, I don't think there's necessity of a counter because they have challenged the award.
No, but who's with the petitioner? What matter were you going to call next? See, why don't you wait till tomorrow?
Lord, I have some major personal difficulty tomorrow. Otherwise, I wouldn't have asked.
Which is the next item to be called out?
47.
Let's reach till 56. Okay.
Lord, item number 47, my lord.
Item 47.
1 minute. 47.
My lord, here petition number 2 and 4 have expired. It requires substitution, my lord. It is regarding freehold, my lord. Freehold application is allowed, but after deposit of the amount as per the application's direction, they are asking higher amount. That is the point, my lord. But factor 2 and 4 have expired.
Where is the land, sir?
Bhubaneswar, GA plot, it is legible plot.
Then you can easily afford to pay, sir.
My lord?
You can afford to pay the higher amount.
No, my lord, it is not payable. Your lordship may kindly see, I will place the, my lord, I have given a synopsis, my lord. Your lordship may kindly see, your lordship may kindly see the synopsis is dead chart, my lord. On 23rd June 2009, the petitioners applied for freehold. Then on 4/11/2009, that was allowed. And we are directed to deposit 1,19,273. Then, my lord, we got that letter dated 4/11/2009. On 17/11/2009, that letter is annexure 1, my lord. Your lordship may kindly see annexure 1. Annexure 1, your lordship, page 12, my lord. There, my application was allowed, and we are directed to deposit the amount within 30 days. And we got this on 17/11/2009. Annexure 1, page 12, my lord. Then, my lord, on 8/12/2009, the petitioner prepared the draft, bank draft, my lord. Page 13, annexure 2, your lordship may kindly see. Then, on 9/12/2009, the bank draft was submitted to the GA department by registered post. Then, my lord, at this juncture, your lordship may kindly see, by 31/12/2009, government took a decision for higher compensation, for higher freehold charges. which is not applicable to me. Thereafter, they did not execute the deed of conveyance in my favor. So I approached this honorable court. Your Lordship may kindly see annexure 3 page 14, my lord.
What is the extent of the land?
My lord, extent of land is 98 feet to 88 feet.
Tell us in square feet or meters.
My lord.
Square feet. How much square feet it is?
My lord, square feet is near about 9,000, my lord.
And you're not able to pay 10 lakhs rupees more.
12 lakhs more, my lord. That is not payable at all, my lord.
Forget it. We're not going to interfere in all this, sir. You just forget it. You think you're going to get Bhubaneswar land of 9,000
my lord, I am liable to pay provided the circular is applicable to me.
You will pass a detailed order. There's no way we are going to allow this.
Your Lordship, can see for a movement, my lord.
Valuable land in Bhubaneswar, just throw away some 10 lakhs rupees more you have to pay. You're not able to pay that.
For a movement, my lord, your Lordship may kindly say.
Tell me the market value of this land today.
My lord.
What is the market value of the land today?
That I cannot say.
You cannot say because it is several zeros.
Yes, my lord.
No, my lord, your Lordship, for a movement, my lord. If your Lordship will
it's about 10
hold that I am liable to pay, I am liable.
Yes. We are
but your Lordship kindly see page 18, my lord. For that is the clear, my lord.
All right.
On the basis of this, I am directed to pay.
Yes.
Before that,
I think we must have passed a stay order in your favor, correct?
Yes, my lord. Annexure 3. For a moment, annexure 3, your Lordship may kindly see.
All right.
Page 14. I am reading, my lord. Annexure. The rate of premium of government land for different purposes is different village of Bhubaneswar municipal corporation.
You already got possession or it's not? You don't have.
No, I am residing since 1957.
Very good.
This is my lord's conversion.
I know it.
Conversion, my lord, only freehold, so that it will be Sthitivan land.
All right.
Your page 14, your Lordship may kindly see page 14. If it is applicable to me, I am liable. Your Lordship may kindly see page 14, my lord, for a moment.
Right.
May I place, my lord?
Yes.
The rate of premium of government land for different purposes in different villages of Bhubaneswar Municipal Corporation area has been revised in GA Department Order Number such and such, dated 31st December 2009, consequent upon the decision of the Cabinet in their meeting held on 14/12/2009. Government, after careful consideration, has been pleased to decide that the new rate of premium as revised by the GA Department Order Number such and such, dated 31st/12/2009, will not be made applicable to for the following categories of cases. I am coming under Roman 1, my lord. Applications pending under the conversion scheme as on 14/12/2009, but otherwise eligible, as the applicant should not be penalized by way of higher conversion charges on account of any delay in the processing of their case. But here my case is since long disposed of prior to this notification. So it is not applicable. It was never pending. And I have paid the premium. They have accepted it. So this circular, my lord, is not applicable to me.
What do you say?
My lords, may turn to page 18, my lords. Which is, my lords, the order of the GA department. If I may read, my lords, just a small. With reference to the subject cited above, I am directed to state that you have been accorded permission for conversion of lease plot so-and-so, dated 4/11/2009. You have been requested therein to deposit the conversion fee of rupees 1,19,273 along with the conveyance deed in triplicate and other documents within 30 days from the date of receipt of the said letter. But you failed to comply with the time limit of 30 days and deposited the same on 11/1/2010.
Okay.
In the meantime, the rate of premium.
Correct. Yes, sir.
My submission, my lord, I have your also kindly see annexed to the DD that I have made on your also kindly see annexed to my lord. That is dated 8/12/2009.
But when did you deposit it?
And I deposited on the next day, 9/12/2009.
That seems to be disputed. They got it only 11 January.
30 day anyway.
In their counter, they have my lord. In their counter, they have said that I have deposited it after 40 days. I was given time limit 30 days from the date of receipt. But I have deposited the same by post and also the deed of conveyance within that period. by 10 days delay, I may not be penalized.
That's all. All right. The writ petition is dismissed. We'll pass the detail.
Item 48.
So in this case, my lord, well, they have paid for a direction to the OP number 2 to execute the lease deed. What happened? I have allotted a plot annexed 1 by the OP number 2, my lord. Thereafter, they requested to pay the balance amount. That I have also paid annexed 2.
When did you pay, sir?
Because I have paid
belatedly.
No, my lord, not belatedly. My lord, that they directed 11,592. I have deposited 8,792, my lord. That annexed 2 kindly she pay 9. No. Thereafter, I made repetition to execute legit. They have not doing, my lord. Only direction to open
delay.
number 2.
This is delay in payment, sir.
No, my lord.
These are all cases of delay.
No, my lord, kindly see 11,592. They have indicated.
Yes.
I have deposited 8,792, my lord.
What was the time for deposit?
But depositor they say only by 36.92.
So you've deposited.
No, only no, that difference only 15 days, 20 days.
Everything is late, sir.
No, may I pray?
People are desperate to get these plots.
No, I pray, my lord, that at the house I am residing, my lord. May I pray? I will file a fresh repetition to open number 2. They will consider, my lord.
No.
I am only prayer, my lord.
Where is Lord Bhuvaneshwar, right?
Yes, my lord.
You can afford.
Sir, a plot, my lord, the house allotted to me,
you can all afford. You can all afford to pay.
No, my lord.
Property is now worth crores of rupees.
No, now I have paid the entire amount.
No. All paid late. Late.
No, only 15 days late. 15 days. Only 15 days.
Only, sir. These kind of cases.
Kindly see, annexed 2, kindly see. Only by 36.92.
All enjoyed the property for long.
Well, I am residing there.
That's right.
I filed a petition.
No, again dismissed.
Open number 2.
All right.
Only 7 days.
Dismissed. Sorry, sir. Sorry.
Item 50. Item number 50.
May I please, your lords. Item 50, your lordship, the lease application is pending before the authority. Lordship, kindly turn to page 5, annexure 1. The lease application is pending before the authority, your lordship, OP number 2. So let them consider my application, your lordship.
This is an encroachment case, sir.
Yes, your lordship.
So you have to answer the notice.
So your lordship, already notice has been.
No, you have to answer the notice in the encroachment case.
Last occasion, your lordship directed. Your lordship, kindly for a moment see the order dated 6/12/2021.
Yes. What's your instruction? Still pending or not pending?
No, we have filed the counter application. Where?
When?
Well, it's 25th of January 2022.
22?
22 minutes.
It's not come on record. What have you said in that?
Please. That in reply to amendments made in paragraph 6, it submitted that the petitioner had earlier encroached in Schedule A land for which the then Tahsildar had initiated an encroachment case in respect of plot number 219. As the scheduled land was Rasta Kisamas Road, the then Tahsildar did not settle the land in favor of the petitioner and evicted the encroachers from the said land.
No, where is the order of the Tahsildar?
Let's see.
You were to, in fact, that was the query. Whether the lease case of the petitioner has been finalized by the Tahsildar.
That order, my lords, we have not annexed.
Acre 0.04 decimal has been settled in favor of the petitioners. ROR has also been issued.
So that is not in my knowledge, your lordship.
That's okay. We'll just record this. An affidavit dated 25th January 2022 has been filed by the Tahsildar Dharamgarh, Kalandi district, inter alia stating that after observing all formalities, an area of AC 0.04 decimal of land has been settled in favor of the petitioners, and ROR has been issued in favor of Shri Jagannath Sahu and Junu Sahu, and also sent through registered post on 21/1/22. Copy of the ROR has also been enclosed. That way of the matter, no further orders are called for. The petition is disposed of.
All right.
Item 52.
Before your lordship take up the next matter, I have a matter 37, your lordship. Just called, I was in another court. Can it be taken up on any other day, your lordship?
We have not passed any order.
Yes.
We're waiting for you.
It can be on the board, your
Yeah, it
lordship.
will be on board, sir.
Yes, yes. Good.
Item 52. 52, sir.
53.
52.
53.
52, sir.
52.
52, both. Sorry, madam. In this case, the order of Tahsildar, your lordship can see the resumption order was passed is the expiry order. Without
This is all appealable, sir. These are all appealable orders.
After 8 years, your lordship already number of cases, your lordship remanded the matter.
That's right.
Due to because,
Same thing here. Counsel with the petitioner
because
seeks
of
leave to
the
withdraw
factual,
this.
your lordship can see the judgment where the factual facts has not taken into consideration.
The
And
appellate authority will deal with it, sir.
my lord,
Counsel with the petitioner seeks leave to
your
withdraw this.
lordship, I will show tomorrow your lordship's order, my lord. The number of cases your lordship demanded, and your lordship can see.
We are remanding only, sir. We're just sending you back to the appellate authority only.
Now your lordship can see where there's a factual order, even if it is appealable, writ can be issued.
Of course it can. Who says no?
If it is an expiry order, your lordship can see here no notice was served, my lord, individually, and the number of cases this honorable High Court.
Same thing, sir. The interim order will protect you till the appeal is disposed of. Counsel the petitioner seeks leave to withdraw these petitions to liberty to file an appeal against the impugned order of the Tahsildar in accordance with law. If such appeal is filed not later than 1st March 2023, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of these petitions, will be considered in accordance with law with the Tahsildar. If the appeal is filed within the time stipulated, the Tahsildar is requested to dispose it off by reasoned order in accordance with law within a period of 4 months thereafter. Till such time, the interim order passed by this court in the present writ petitions will continue.
I will file within 1 month, my lord.
You said 4 months, sir. 4 months. You're protecting your status quo for 4 more months.
And the annexure, your lordship can.
All the originals be returned subject to substitution with photocopies. All right.
Item 53.
53 also same.
Item 54.
Another covered matter, your lordship.
1 minute, sir. 1 minute.
159.
54. Who's for the petitioner?
54.
All right. None appears for the petitioner. Dismiss the non-prosecution. All right.
Item number 55.
My lord. 159.
1 minute, sir. 1 minute.
Item 55. 55. Item number 55, sir.
None appears. Dismiss for non-prosecution.
My lord, this is a covered matter. Item 92, may I please? Sir?
All right. 55 stop. Now 92 is covered by what?
My lord, by your order, in order number 3, order number 6 in light of order number 3. Sir,
which is writ petition?
Writ number 20310.
We have no memory, sir. Without seeing the order, we can't remember anything.
Sir.
What is all this? Covered by what? It's some interim order.
Order number 6, the next page.
Which number?
Subsequent purchaser.
Yes, ma'am.
All right, same order. I think instead of 1st June, you say 1st March 23. The status quo order passed on. Look at the date. You put that.
This is item.
Is this item?
My lord, we have already appeared before the ADM.
Item what?
Sir, the same item 92.
92.
159.
Lord, item number 56.
Who's appearing 56? None appears to the petitioner. Dismissal not possible. All right.
Very grateful.
All right.
159, my lord, I am the bona fide purchaser. He purchased in the 1981, but the ADM cancelled in the
Same order. Same. All right.
159.
Dates have to change.
Under Annexure 3, he cancelled the same without including the part.
Not such a big order, so we can't.
Directed there and he'll dispose of the interim matter shall be continued.
All right. On the short ground, don't follow this order. On the short ground that the 159.
159, madam. Vishnupriya Dey.
Just show me that earlier order. 92.
159.
The same, you pass a 92 order, give the same date of 1st March. Pass this order. So 92 and 159 will be this order. Right. All right, let's get up.